Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
No, I'm not Peyton Ansley John Milton. I'm the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
Thank you. And as to Mr. Milton, is there competency concern or?
I am not represented by anybody besides myself. In my sovereign capacity, appreciate you.
Thank you, Your Honor. I did have an opportunity to speak to him. I read him the reports.
Who is him?
Don't interrupt.
I read him.
You just sit quietly.
Thank you.
I read him the report so that he will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented.
All right. I screwed. Why can I not hear myself? Testing 1 2, check 1 2. Test 1 2. Oh, there I am. Found it. Welcome. I messed up this morning, and I see it all over in chat. As a matter of fact,
I wake up, I hear it. I walk down the steps, I hear it. Open the back door to let the dog out, you hear it.
yeah, I hear it. I spelled sentencing wrong, but I fixed it. I fixed it already. Did you look? I had already. Well, I fixed it right after you told me. All right. Good morning. Welcome to the Court of Public Opinion. Usually I get that part in while the music's still going, but here we are. Well, most of us. There I am. Where's the rest of me? Yeah, there. All right. And as expected, Greener's first in chat today. Greener's, congratulations. Please don't tease RA about his accent. Yeah. Too soon. Good morning. Welcome, everyone. Come on in. Corey Richards has a hearing today. That's going to be amazing. We're going to watch for that. We have sentencing of Wade Wilson going on today. That's going to be starting here just momentarily. We have catch up from what happened on, was it Wednesday? No, Tuesday? Tuesday in the Karen Reed trial. And we only have the same amount of hours today as we have every other day. So I don't know how we're going to fit it all in, but buckle up. We're gonna try to get everything in, and just pray. Keep your fingers crossed that no breaking news happens in like Sarah Boone's case, or heaven forbid, something like BK. Corey Richards, that could go crazy with it's podcast day as well. Yeah, let's not forget that part.
The zombie apocalypse may be upon us.
I hope you guys don't have any plans. Say for like maybe 12 hours. I'm thinking 12 hours is what we'll need today just to get the basics covered. And that leaves me zero time for prep for the podcast. But here we are. Good morning. Welcome. It's good to have you here. Oh man. Slept in a little bit. Still sort of waking up, actually, if I'm 100% honest. Still sort of waking up. But we're here. Let's see. Misbehaving. Good to have you here. Welcome. We've got a couple. Look at this. Kay in South Carolina. 17 months. So glad to be here. Kay, thank you for your wonderful support. You're absolutely amazing. Thank you for all you do and have done for the channel. Appreciate that. Would not be the same without you. Thank you for being here. We have, let's see if there's anything else other than Greener's. Greener's internet, still yours. Keep doing what you were doing the other day. Other than that part where it went, so you don't do that part, but all the rest keep going on. That'll be great. And I'll love seeing you on X as well. Greener's, let's see, I have more popcorn, so I'm ready with the seatbelt on. That is good. That is really good because we have Wade, right? We have Karen. Well, we're waiting for Wade to come back. But we have Karen. We have Corey, we have podcast. Let's see. Oh, my goodness. Nikki says, I had my 14th month anniversary yesterday, but you didn't see it. You deleted this, but I saw it before you did that. How does that give me some points? I'm sorry, Nikki. I'm sorry I missed your anniversary message. Congratulations on 14 months, for sure. Wonderful. Greeners is the ultimate internet winner MVP. We'll have to come up with a title. Wrong answers only in chat, please. What's Greener's new title? Due to his pervasive winning. If this were a casino, Greeners, we would have kicked you out a long time ago. Just on, to be on a level with you. Luckily, it's not a casino. There's no prize for anything here other than internet ownership, which is more of a sentence, honestly. Let's see if we have any birthdays today. Wrong answers only. Yes, wrong answers only for Greener's title. More of a sentence. You want to start with me, Greeners, today? You of all the days, today's the day you want to start this here with me? No bueno. No bueno. Buffer, Christina is celebrating a birthday. Their special day with us. Christina, happy birthday. I can do better than that. We can sing to Christina. And by we, I mean all of us, not just me. It's too early in the morning to do a solo. I would never dream of doing a solo first thing in the morning, especially a cappella, but with a little bit of music. If you guys sing with me, maybe. We're going to sing to Christina. Warm up with me. La, 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 la. There we go. Blend your voices with mine. We're going to celebrate Christina's special day. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, dear Christina. Happy birthday to you. Happy birthday, Christina. It's Thursday. It's not quite a Friday, but it's Friday Eve. That's worth something. I'm doing the shuffle dance when you're sitting down. This is how you do it. Yes, dance classes follow this live stream. So, happy birthday, Christina. I realize there are a million places you could be, a million people you could be with to celebrate your birthday, and who want to celebrate with you, but you've chosen to be here with us, and the privilege and pleasure is not lost on me. Thank you for doing that. Hopefully we can make your day more specialer. Maybe even specialist. Is that one step above specialer? Help yourself to free pancakes at Denny's before they go out of business. I'm not, Denny's, don't sue me. I'm not insinuating that they will go out of business. I'm just saying that companies do go out of business, and if Denny's were to get pancakes before they do, that's all. I have no inside tea leaves, stock information, company shareholder information that would indicate that anything is wrong at Denny's, other than the fact that I've talked about it here on the show. Oh, we've got Dane Mama who's the birthday today as well. So let's do another verse. Ready? Happy birthday to you. Happy birthday to you. Happy birthday, Dane Mama. Happy birthday to you. Dane Mama, all the good things that I said about Christina, you too. Does that count? Can I just do that? Happy birthday. My gift to you, I bring you the podcast on your birthday. A special podcast edition just for you guys. So, oh wow. I sense we might as well stick around for the drum solo. No sense fading out right now. Ready? Everybody ready with your drumsticks? Here we go. There was. I nailed everyone. I could hear it in my head. I got the toms and then I don't know what this is supposed to be, a cymbal, but it does the wrong sound. I'll have to get that programmed. Happy birthday, Dane Mama, as well. Christina and Dane Mama, have a wonderful, wonderful birthday. All right. Let's see. You guys are hilarious. Nikki says, by the way, Nikki, I'm sorry I missed your chat. I love it here so much. Thanks for all you do. Thank you for the super chat, Nikki. Great way to kick off the morning that way. And we are going to kick off the day with the Wade Wilson hearing. Now, just so you know, we are going to also do Karen Reed And while we're doing that, I'm keeping my eye to the ground down there in Florida to see if they decide to finally file 58 pages of Sarah Boone goodness, also known as her latest letter. So we're watching that, and then we've got Corey Richards in Utah, Park City, in that same, I think the same courtroom that Gwyneth Paltrow was in for the ski case. So that's going to be a lot of fun as well if we get something out of there. Well, let's see, nothing yet on Sarah Boone, so we can put that on the back burner. That's good. Let's see. Don't need that. Ooh, toys. I already have this one, but I like looking at it anyway. Okay. That's a fun little mixer. I want to get a digital mixer instead of a analog mixer. The workflow, the audio path is a little bit different. Judge Decision Day in Karen Reed case. Yes, that's coming, but first we have this.
All right. Let's bring out Mr. Wilson.
Bring out your debt. No, that's different. Sorry. Not appropriate in this setting.
Okay.
Mr. Wilson expected to be in jail clothes today and not a suit. We'll see.
Nah. Okay. I'll clean it when I get back.
Do you want a Kleenex to wipe it? Nah, I'll clean
Let
it
the
when I
record
get
reflect
back.
the state's president, defense counsel, and the defendant are all present.
That or they just dress really
proceed?
nice in jail?
Yes, Your Honor.
Is the defense ready to proceed?
We are not ready to proceed. I filed a motion yesterday to inform the court. Thank goodness Mr. Hollander is with us, but he is still recouping. He was incapacitated for 3 days. If he wants to explain it to the court at the bench, I'll let him do so. I don't want to broadcast it. I don't think it's anybody else's business. But he was unavailable to assist us. During that time period, we finished conducting interviews of my client, our client, excuse me, and I had an opportunity to spend a lot of time with our mitigation specialist. I want to introduce you to Ms. Perez. I've had time to talk to both of our mitigation specialists. They're compiling, Dr. Mills has already compiled his data. I think that Dr. Eisenstein is done with his. We have to send that compiled data to the state's experts so he can review it. And subject to the court's approval, we have depositions scheduled tomorrow morning of the experts. Respectfully, I was requesting continuance until Monday, or an adjournment until Monday, so that we can all be properly prepared to proceed, because we are not, partially because I had to do this by myself. Mr. Hollander was unavailable.
State, your response?
Judge, the state is in a predicament given the fact that we are responding to defense counsel's late disclosures of a number of records that we received just yesterday, as well as a lot of the raw data that is being compiled by defense counsel as it relates to the experts.
They're also not ready?
Unfortunately, we're just in light of the compromised position that the state finds itself in, we are ready to proceed today. However, in light of being able to properly respond to defense counsel's presentation, we would not be opposed to the adjournment until Monday in order, for our experts to review the information that's being provided to us and allowing ourselves to be able to properly respond at the same time. So,
all right.
So Monday.
If I can, part of the problem is Dr. Eisenstein, because he's a neuropsychologist. He has this raw data. He can't reduce it down to anything until he actually goes back to his office in Miami and puts it into his computer. The program in his office in Miami will extrapolate the data, and then he can better render an opinion. Obviously, he can't do that.
I guess my question is, what prevented him from doing that within the time frame that was already given? That last week. You said, the time, because we continued this from April to give time for all of the experts to do their things. But what is it that delayed him from getting it done by today?
If the court recalls, the problem we were having, I'm not going to go through the whole scenario again, but I got appointed to the case when I tried to get the experts appointed who should have been appointed 3 years ago,
Thank
or 4
you, Teresa.
years ago.
Wonderful 2 months.
I couldn't do that because the JAC was not accepting the order of appointment that Your Honor executed and was filed in the court file because it didn't exclude consideration of regional conflict counsel. I submitted a new order to the judge when I found out from JAC why they had declined to accept the order of appointment for myself. Your Honor signed a new order, at which time then I could go forward and seek appointment of the various experts. I filed motions. We have to wait for JAC responses. JAC was slow in responding. I got everybody up to speed as soon as I could.
Well, I thought those dealt more with just authorizing the payment for their work.
It did, but they can't go forward until those documents, until they're appointed, none of these doctors can go forward. As a matter of fact, the defense is basically sacrificing 2 of its experts to go forward on Monday because I have 2 that aren't going to have time to get involved in the case. So we need to go forward with the 2 that we have that have already conducted their examination. As a matter of fact, Dr. Mills flew down here from North Carolina twice to interview our client. Dr. Eisenstein spent Tuesday and all day Wednesday with our client. We've done everything that we can to be ready by today, and we can't do it.
Okay. What else needs to be done to be ready by next week?
Dr. Eisenstein needs to compile his...
what does that mean?
He runs a series of tests. He has to put those test results into his computer, and then the computer provides a documentation as to what the results are from that evaluation. I need to send that off to the state and their expert. He's going to evaluate it. We need to take the deposition of all of the experts tomorrow morning, which is already scheduled.
Okay. So he'll have that data compiled and done through his computer by tomorrow morning?
Yes.
By today.
By today.
By today.
By today. He's going back to Miami.
We can have it, yeah.
Okay.
Yeah, because obviously Dr. Herkov is going to need some time to go through that data. So.
All right.
I'm not going to come back here Friday or Monday and ask for more time. I appreciate the consideration, and we all appreciate the fact that we're inconveniencing 14 people. But
well,
by the same token, this is...
I understand that. I'll have to inquire with the jurors about when they're available next week.
But under no circumstances is going to take past Tuesday.
Okay.
Well, just for the record, this is the lawyer's version of the dog ate my homework. Okay? He's not ready. He's quite convincing about this, but the judge, because the state
just
agrees.
think for a second. I think that we probably need to bring the jurors out, number one, inform them that
there's been a delay outside of our control.
We're not able to proceed today.
This is the judge's fault. Don't blame it on anybody else.
However, we believe we can proceed Monday or Tuesday.
Monday.
Experts that are canceling their stuff to come back Monday.
So we got to do it Monday.
Yes.
Okay. Then I can make that arrangement. I've got a long docket for Monday, but I'm sure that my judicial assistant will be able to rearrange that if necessary.
He puts all the work on someone else and says, "I'm sure it can be done."
So we want to bring the jurors in, inquire about their availability for Monday. Are we still talking Monday and Tuesday, though? So Monday and Tuesday. Explain to them that there's something that has occurred that we're not, well, what do you want me to tell the jury?
He's like, it's not my fault, but I can't tell them it's your fault.
Something occurred beyond our control. We've done everything that we can to be ready, but we're not going to be ready until Monday.
How about due to unforeseen circumstance?
That's fine, Judge.
We're not able to proceed today. However, we would be able to proceed Monday.
Judge,
if you are available, which means you would be needed Monday and Tuesday. Is there anybody here that will not be available on Monday or Tuesday.
Yeah, I think during our jury selection, do you mind if I remain seated?
That's okay.
I think during our jury selection, we pretty much cleared out everybody who wouldn't be available, like through the 28th or something like that.
I think that's correct.
So I think we should be okay with.
I remember a few jurors discussing trips or travel plans in July, I believe, but
yes, sir.
I think we're okay.
Let's not mess that up.
But we'll find out.
Judge,
do we have all the jurors?
Yes, Your Honor.
Now, we have the jurors plus the alternates?
Yes, Your Honor.
Okay. So we'll bring them all back out. I'll ask them that question, and we'll see what they say, and then I'll send it back out, and we can discuss it.
The judge is trying to reinvent the wheel as far as terminology
Let's bring
goes.
the jury in.
There's probably a Hallmark card just for this occasion, Judge.
Judge.
You might want to.
What?
I needed to wear jeans.
That's okay.
Okay.
Who's wearing jeans? Wait, your client's better dressed than you are? Is that... Judge, I can't proceed today. I only had a clean pair of Levi's. I could not find my good pants anywhere. This is absolutely amazing. Oh, it's the state that wore jeans? Or the defense that wore jeans? The dog ate my suit pants and my homework. Yeah, the defendant's posture looks completely natural and normal. There's nothing strange. Jurors entering. Love that sound. Welcome to Jumanji. That's the voice. It might be the same guy. My name's Nigel. The jurors are all like, last day, finally.
All right, welcome back, ladies and gentlemen. Please be seated. So, ladies and gentlemen of the jury, due to some unforeseen circumstances, we are not able to proceed today. We are able to proceed next Monday and Tuesday. Is there anybody on the jury, by a show of hands, who would not be available for us to proceed on next Monday and Tuesday? Seeing no hands, I have a couple other inquiries. One is, by a show of hands, was there anybody that was not able to follow the court's instructions about doing any research, looking up anything, or discussing anything about their service as a juror on the case? Very well. Seeing no hands. The other question is there anybody here on the jury, by a show of hands, who cannot continue to follow those instructions about not doing any research, looking up anything, or discussing anything about your service as a juror on the case? Seeing no hands. Then what we will do is I'm going to send you back, and then we'll make sure about our scheduling. I believe what we'll do is have you come back Monday morning at 9 a.m. I just want to confirm with counsel that that's okay, and then we'll bring you back in and release you for the weekend.
You want to check with defense, make sure their client's available too.
Leave your notebooks here.
Yeah, take no notes today. So defense is wearing jeans. It might actually be related to a health issue, so that's cool. Now, do you want to explain to your client what happened? Lawyers on tippy toes, clients hunched over at the waist.
Let the record reflect the jury's secretary. The court, any objection to my inquiries of the jurors?
No.
Okay. So we can begin Monday morning at 9 a.m., correct?
Yes, sir. I've conferred with my two experts, and they're available.
Very well. And all the discovery or what have you that needs to be turned over to the state will be turned over today?
Hopefully this morning.
But today?
Yeah. Oh,
okay.
yes.
All right. And then you all be able to complete what you need to complete by Monday?
Absolutely, Judge.
Okay.
You think you'll be able to
Are
find
there
a pair
any
of
other
pants?
issues the court needs to address prior to Monday morning?
I don't believe so.
Okay.
No, Judge, no issues as it relates to what has given rise to the postponement of today's proceedings. I think that in an abundance of caution, while we're currently together, we conduct a charge conference with regards
Right.
to the jury instructions.
We can do that.
Very well.
We can do that. And Mr. Wilson, you understand what's going on, and you're in agreement with the postponement till Monday?
Yes.
All right. I have a copy for each parties as far as the preliminary instructions. I believe they were emailed a while back. You all got a copy of those? If you don't, I'll give you a hard copy. One for the state and two for the defense over there. These were the preliminary instructions, I believe, the state promulgated.
I like that girl's hair.
Several weeks ago.
Oh, it's two
And
colors.
there's a
That's why.
portion in there, I believe,
looks like it was
regarding
like
the defendant's
changing
right
color
not to
based on what-
testify. Did the defense want the court to read that part of the instruction?
I don't know yet. I'm going to meet with.
It was a yes/no
client,
question. Did you read that
either
part of the
today or
instruction?
tomorrow.
Okay. Well, I'll need to know Monday morning, obviously, before I
I'll
read the
try to let you
preliminary
know
instructions.
before
That's
then.
fine. That's fine. And then the other instructions that you want to go over are the final instructions that were sent.
Yes, Your Honor.
Okay. The other thing I want to do, I want to make sure of, is that we get all of the jurors' phone numbers to give to the clerk so that if anything changes or what have you, any problems, we can get a hold of them. So we'll do that in just a minute after we bring them back out. I'll tell them that the bailiff will take the phone numbers from the jurors.
You don't have their phone numbers yet? I think that would be like
Judge,
sign in.
in an abundance of caution, I'm going to ask that the court read that instruction with regard to right to remain silent.
Okay. It's very similar to the preliminary instructions that are standard in every case.
It is. It's fine, and because that decision it can be a spur of the moment thing, and we.
Absolutely. All right. So I will read that part of the instruction then. Have you got the other instructions? I know that I have.
What other instructions?
Proposed, but there's nothing filled in. It's just the standard penalty phase instruction, I believe.
Yes, Judge. I
Judge is
can go
wishing
ahead
he had
and
a
print
beard
out the
right
set
now.
for everyone, if you'd like.
Yeah, it's not there. There's
Once
like
again,
nothing.
I was waiting on defense counsel to provide me with.
That's fine. Do you all have a set of jury instructions?
Yes.
Oh, great. No. I meant, do you have your own? Do you have any proposed instructions for yourselves or any special instructions?
No, I do not, other than we would need to insert on page 4, among the mitigating circumstances you may consider are, I need to provide that list to the state, and then we will have a discussion as to whether or not there's any evidence of those.
Right. When do we anticipate
Yeah,
that's going to happen?
That should be done already.
I'll try and do it today.
Okay. And then you can share those with the email, and that way I can have a copy of them
New
to
technology.
review as well.
Email.
I did, I need to confer with my mitigation specialist because she may have some.
Okay.
The ones that I compiled were based upon the testimony of individuals
Okay.
during the guilt
So
phase.
I don't think we'll be able to do a full charge conference then on the final instructions at this point because we don't know what's going to be in them at this point. I think that you can confer over the weekend, and if you can come up with as close as you can get to a final draft of those before Monday morning, that would be helpful. Let's talk about scheduling Monday morning. We expect the state will start with their opening and go from that point forward. How long do you think your presentation will take?
Yeah, as far as the state's portion goes, Judge, I wouldn't anticipate that to take any longer. I mean, as far as evidentiary-wise.
I'm just trying to gauge over the 2 days what our schedule is going to be like.
Yes, Judge.
Make it a day.
I anticipate, openings, and then go into presentation of the state's evidence
Yes.
portion.
How long will it
wouldn't
take?
take any longer than, say, 20 minutes.
Okay.
20 minutes.
I mean, as far as the evidence portion goes.
Okay.
Yeah.
And obviously, we have two experts, and
Certainly.
I'm going to discuss with them what I anticipate their testimony to be. I got to get my questions, finish getting my questions together. So,
Okay.
I mean, couple of hours, I anticipate.
I'm not pinning you down as to how much exact time you're going to use. I just wanted to get a ballpark just for the jurors' purposes and the courts. So, do we believe it's possible to have all of the evidence for this portion to be completed on Monday?
Yes.
Okay.
I think that my thought is that they would be done potentially by lunch.
Okay.
With their experts, unless it goes longer than anticipated, then we would put our expert on.
Okay.
And then we'd be ready for closing. So
So you might be able to close Monday afternoon? Okay.
I'll be ready to close whenever.
Right.
But,
Just not now.
We can't close till everybody rests. So I just want that's really what I'm asking is
No, but I don't anticipate that it's going to take all day Monday to present the
Okay.
evidence.
All right. Okay.
Statement's 20 minutes. That's for.
Is there any other
introduction,
issues or any other things the
openings,
court needs to
and
address
evidence.
then before Monday?
20 minutes.
Are there any other issues? All right.
No.
Okay. All right, then I will bring the jurors back out. I'll let them know the bailiff's going to get their phone numbers for the clerk to have so that if she needs to contact them for any reason, she can. And then we'll release them to come back Monday morning at 9 a.m.
Okay.
Agreed?
Yes.
Yes.
Okay.
I agree. Verdict watch Monday afternoon. Sorry, all those words got away from me. The jury's going to be dragged back in and told the same thing they were told before.
No, they've already done that.
Okay.
Who is the red-haired lady behind him? I do not know. I think the hair color looks beautiful the way it does look prismatic. Like the angle you look at it changes. Why? Cameraman, why? It changes the color.
Jurors entering.
That was weak. The first one was much better. Is he doing like a sign on purpose?
All right, please be seated. So, ladies and gentlemen, two things. One, before you leave, when you go back, I'm going to have the bailiff write down all of your contact phone numbers to give to the clerk so that we can get in touch with you if we need to. Second thing is we're going to release you to come back Monday morning at 9 a.m. Please continue to follow the court's instructions regarding not doing any research, looking up anything, discussing anything about your service as a juror in the case, watching local news, reading newspapers, anything like that. So with those instructions in mind, you are released until Monday morning at 9 a.m. and the bailiff will take you back and get your contact information for the clerk. All right?
All right.
Thank you.
There we go. Well, that was fun. Now we get to go on to Karen Reed. So I'm not going to restart this. I'm just going to redo the title. I'm going to change the graphic to be something else. Where's my logo when I need it?
All right, let the record reflect the jurors exited
Wait,
the courtroom. Then we'll, if there's nothing else, we'll be adjourned until Monday morning at 9 a.m. Okay.
Yeah, I have a. Oh no, I've just got a couple more orders coming your way.
In what regard?
Payment.
Okay, fine.
just
All right.
one issue
Thank you.
about money. About money, Judge.
Okay. Tell me what
All right, there we go. All right, so what just happened? The dog ate his homework. The jurors are not ready. We're going to start again on Monday morning and try for that. In a nutshell, the state says they're ready, but at the same time, the state says they're ready without having the information that the defense is still compiling and will be giving them. So the state really isn't ready because they're going to want time to look at that, even if it's just, an hour or two. All right, hang on one second. I need to find my logo. I think it's on desktop. No. Yes, it is. Okay. Okay, we're going to save that. And put this also on Karen Reed playlist. What day is it? Are we on Karen Reed? Does anybody know off the top of your head? I think it is. Let's see. I think we're on day 27. Right. You find it day 27 for sure. This is the vetting. No jury, but vetting will occur. Trying to skip the fan at the beginning. All right, we're back, right? Cut to there, and cut to here. We have court. Ready. We are behind. We're behind 1 day, so we're now looking at this is going to be defense testimony from expert witnesses that they want to admit or have admitted into court. The state the Commonwealth has objected to them being allowed in for a number of reasons. We're going to hear that today, but they're spicy and they disagree with what the Commonwealth witnesses have said. So we're on the voir dire day. No jury today.
Thank you. Maybe see the close down session.
22117, the Commonwealth versus Karen Reed.
All right. Good morning, counsel. Ms. Reed. Are all of the witnesses here, Mr. Jackson?
They are, Your Honor.
I'd like to hear from Dr. Russell first. Are you both prepared to?
Your Honor, I'm so sorry. I could not hear you.
I would like to hear from Dr. Russell first. Is that her name?
Russell. Dr. Russell, yes. The order would be, I would propose based on scheduling, Dr. Russell, Dr. Wolf, Dr. Reichler.
Okay, then that's good, because that's the order I'd prefer. So, all right. Do you have a CV for her? Good morning. Morning, Tori. Do you have a CV I could look at for her, please?
Let me see if I got it in my notebook. I thought I did. Yes, I do.
And she has not written a report?
She's not.
All right, let's bring her in, please.
I think all experts should be required to write reports.
Before we get started, can I get an understanding? We started to say it at sidebar the other day, and you said you wanted to put that off to get to the witnesses. But I need a little bit of an understanding of what the court's expectations are. My understanding of a voir dire, which this seems a little unusual in terms of the timing of it.
The understanding of the voir dire is this is for the Commonwealth's motion to exclude this testimony. All right? That's what we're here for, the Rule 14 violation.
Is that the same with Dr. Wolf and Dr. Reichler?
Well, I thought that would help both of you. The Commonwealth has nothing on that, and you say you haven't been able to even talk to them at all about this case.
That's correct.
So I want to find out if they have any credible, competent evidence to put forward. So we'll have a voir dire on them as well. But
So
for
that-
Dr. Russell, what we're doing here today is there's an alleged well, there appears to me to be a violation of the reciprocal discovery obligations of defense counsel regarding Dr. Russell. So let's hear from her today to see what the appropriate remedy is for this violation.
So my intention is to ask her so I have, the court understands my sort of guardrails. My intention is to ask her what her qualifications are, which is that's the basis for a voir dire. And that's where I'm going to stop. I'm not intending to ask her what her opinions are, conclusions. I'm going to ask her if she's come to opinions and conclusions, but I don't want to have to examine her concerning her full opinions, her full conclusions, what she's based those conclusions on. It's unfair. We have provided the defense everything that the prosecution, everything that we need to provide to them in terms of disclosure. They've got the equivalent of a report. They've got a summary of what she's going to testify to.
When was that provided? My order was 1 week from the start of trial, right?
Well, we didn't, Your Honor, in fairness, they didn't even finish their discovery 1 week before the start of trial. So it's a little unfair for us to be put on the same.
1 week from the filing of the certificate of compliance.
Well, I don't know when there's, I can't remember. My co-counsel indicates it was the day before trial.
Okay.
So during the course of, look, trial is a dynamic thing. During the course of the trial, I did not know who Dr. Marie Russell was at the time that they filed their certificate of compliance. We then attempted to, and did, give them the reciprocal discovery that we were obligated to do after they filed their certificate of compliance.
When?
Within 3 days of that. We had been giving them information prior to that, but at least within 3 days of that. We've continued, so the record's clear, we've continued to get additional discovery from the Commonwealth in notices of discovery throughout the trial. They have not finished. In fact, during the trial, they interviewed Jen McCabe, apparently, had a full interview with her. Lieutenant Tully took a report, dated the report, and then they held on to that report until after she testified. The interview, the report, and the completion of the report were all done before her testimony.
Do you need to call her again?
Your Honor, that's not my, and I think the court understands, that's not my point. My point is not I need to call Jennifer McCabe back. I've done the damage that needs to be done on Jennifer McCabe. The point is...
I'm sorry, I missed that. You've what?
I've done the damage that needed to be done on Jennifer McCabe. I don't need to call her back. The point is that what's good for the goose is good for the gander. The Commonwealth doesn't get to stand in the position of piecemealing and feeding us information, reports, discovery throughout the course of the trial. And by the way, when we then got seminal information about an expert that we did not know about, never met, never heard of,
how did they find
within
this expert?
3 days of that, we provide everything that we have about that witness to the Commonwealth. They can't then turn around and say, oh, well, it's all the defense's fault. So we want to have a voir dire, which means that the euphemism for that voir dire is we want to have two bites at the apple.
Okay.
We want to be able to completely cross-examine her, then go back to our expert, and if she testifies, cross-examine her again after consulting with our expert. That's 2 bites at the apple, and that's not fair. If the court wants to hear whether or not Dr. Marie Russell is qualified to testify about the arm injuries, that, I believe, is the parameters, the proper parameters of the voir dire, and that's what I'm prepared to do today. But I wasn't planning on getting into the substance of her testimony because that's been provided. And I don't think Mr. Lally should be able to get into the substance of her testimony because he knows what the substance is because, like I said, that's been provided.
All right, so I disagree. I'm going to hear from the Commonwealth on this. Is it Ms. McLaughlin or Mr. Lally?
Your Honor, just briefly in regard to what counsel was referencing with Ms. McCabe, it was not a full interview by Lieutenant Tully. It was and I don't have it on me at this moment, but I can give the court a copy of that report. But essentially it was Ms. McCabe met with Lieutenant Tully, looked at some video, and was asked a single question. That report wasn't available. I didn't have it until after Ms. McCabe testified, but it was given to counsel prior to Lieutenant Tully testifying, and there were no questions asked of Lieutenant Tully in regard to that. My issue, and you know, I wasn't asking for a voir dire as it proposed to, as it relates to Dr. Russell, is that we first heard of Dr. Russell on May 21st, which was, I think, 6 weeks into trial.
Right, so that's what I asked, and you told me it was 3 days after the beginning of trial, Mr. Jackson.
No, I didn't, Your Honor. I said this at sidebar the other day, and I just said it again today. I let the Commonwealth and the court know about Dr. Marie Russell 3 days after I learned about her, which was the 17th of May. I think it was the 17th of May. I had never heard of her. I didn't know who she was. We made contact. I determined that she would be useful for the jury in terms of specifically the injuries to John O'Keefe's arm. I then had one conversation with her, then immediately, within 3 days of that, turned that information over to the prosecution. So I didn't say that I gave this over 3 days into trial. That's not what I said.
All right, but you were ordered to do it. Ms. Gianetti, what was the date? What, you had 1 week from when?
The day before trial. So it would have been, I believe, April 15th. So what we knew as of that date, we were required to turn over.
All right, I need to take a quick recess.
What? All right.
Wow. Okay, so there's back and forth here. This is interesting. The judge is focusing on the deadline. What date were you supposed to turn this over? The defense is focusing on, we complied based on what we knew at the time, and we got later stuff later, and we gave you everything within 3 days when we got the later stuff. Plus, Your Honor, it's not fair because they've been doing it to us. Okay. The defense also has an issue where they say, we, for this voir dire, we only want to go into her CV, her expertise. We don't want the state, the Commonwealth, to see what she's going to testify to. And this Commonwealth, for the prosecution, is just saying, we only object because it's late. And so we have all these different reasonings for the same event. The judges thinks this is going to help both sides. I think, honestly, this process only hurts the defense right now. That they stand to lose a lot by doing this. Judge had to go get her good pen because the one she was using was not working. Brief break. We're back. So let's see if first of all, let's see if the judge limits the testimony just to the qualifications, which is funny because the objection, the motion is not based on qualifications. The motion is based on the timeliness of the notification of the expert. This is interesting. I want to see how this unfolds, and I also want to hear what the experts have to say because it sounds like it was a miraculous discovery of an expert who reached out to them.
The Commonwealth's motion, the Commonwealth's renewed motion first.
Sounds like the judge is asking for that, the Commonwealth's motion, the copy of what they put in their motion and what the problem was with the defense.
Never mind, Jim.
Never mind, don't, Jim.
Paper 360.
If you don't,
got it, yeah.
You got to be faster, Jim.
All right, so the Commonwealth has moved that I exclude the testimony of Dr. Russell based on a violation of the reciprocal discovery obligations of the defense. So I do find that there is a violation of the reciprocal discovery obligations of Rule 14.
That's bad.
And I'm quoting from the notes, the importance of this, the reporter's notes to the old rule, and as you all know, we're in the process of updating that rule, but the very integrity of the judicial system and public confidence in the system depend on full disclosure of all the facts within the framework of the rules of evidence. To ensure that justice is done, it is imperative to the function of courts that compulsory process be available for the production of evidence needed either by the prosecution or the defense. So, what we're here to do today is decide a remedy for this violation. And that's why we're having a voir dire. I am not prohibiting the Commonwealth from anything on their examination of witness Mr. Jackson. The alternative is she doesn't testify. Ooh. So the Commonwealth has not received the appropriate discovery from this witness. So we're going to have a voir dire, and they can ask her anything that they think they need to ask her. So
that's a sanction and a half.
Those are the parameters of this morning.
As long as I know the guardrails, that's fine. Just to close the loop on the record, my understanding, and Ms. Little can probably speak to this more intelligently than I can, but during the middle of trial, there was a witness that we had never heard of, we did not know and didn't have a report for.
Who is that?
Dr. Fowler. F-A-L-L-E-R.
Okay.
If the court remembers, he's buried in the middle of about 75 witnesses. So he testified to alcohol levels, et cetera, and protocols at which institution? At Good Samaritan. And we didn't have that information either. We didn't throw a fit. They said we were going to provide this information in a timely fashion. As soon as we know that we're going to call him, he's got to be on our witness list. We didn't know one way or the other what he was going to say. We didn't have a report, and we went on about our business. That's what we were doing as well. And by the way, I would note that the notes and the report under Rule 14 require disclosure of information you have. I just don't want the court to think that we were sitting on information that we didn't turn over.
I'm not saying that. It's just, this isn't as if it was something that the Commonwealth brought up and you needed to scramble. This is entirely of the defense position. So,
I understand.
All right, so that's the big difference. So why don't you go ahead and call her?
Okay. May I be excused to call her?
Yes.
Okay, he wants to go out and talk to the witness. There's going to be a very quick discussion there. I wonder what he's going to say to her. But defense left you with a choice. Either you don't get your witness in because he violated the discovery rule, or you get your witness in, but as punishment for violating the rule, Commonwealth gets to ask all the questions they want. And they get to really probe the depths of this witness's testimony. That does give him 2 bites of the apple, but that's the sanction the judge gives after she finds that there was a violation.
Doctor, I'm just going to ask that you be mindful and step up. Ask that you remain standing and face the court this morning.
Raise your right hand. Do you solemnly swear the evidence given in the court, the case now and here, and the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Let's take this name.
Morning.
Jim's being extra attentive, helpful for the witness. Thank you, ma'am.
So I'm going to ask you to keep your voice up. Speak right into that microphone, doctor, okay?
Yes.
Thank you. All right, go ahead, Mr. Jackson.
Thank you, Your Honor. Good morning. Could you please state your name and spell your last name for the record?
Yes. Marie Russell, Russell.
And I'm going to echo what the court just indicated. The air conditioners are on, so please keep your voice as elevated as possible and maneuver the microphone however you need to, okay?
Okay.
Just stop
Dr.
maneuvering
Russell,
it.
what do you do for a living?
I am a retired emergency physician and forensic pathologist.
And tell me what education you have, going all the way back to the beginning, that qualifies you as an emergency physician and former pathologist before you retired.
Okay, well, I've had about at least 16 years of formal education beyond high school. Initially, I started at MIT, where I did my pre-med courses. I had always wanted to be a physician. And so I went to MIT for a year, took pre-med courses, and then I had an unusual life event in that my mother came down with cancer, and she subsequently passed away. During the time away, so I took some time off from school. During that period of time, I decided to explore another interest of mine, which was law enforcement. And so I took some courses in law enforcement, and I became a full-time police officer here in Massachusetts.
What years were you at MIT?
That was 1972 to 1974.
It's going back before my time. But
I did. Once I became a police officer here in Massachusetts, I attended the Boston Police Academy where I graduated.
What year was that?
That was in 1977.
During the course of your training as a police officer, did you have any specialized training in hit and run and accidents and investigations?
Yes, I did.
And which agency did you work for as a sworn peace officer?
I worked for the city of Malden full-time for 7 years.
That would be from 1977 to 1984, approximately?
Correct.
During that time, did you continue your education in any way?
I did. So I took as many courses as I could from the Massachusetts Criminal Justice Training Council, which included a course, a several-day course in hit-and-run accident investigation. I took courses in forensic photography and numerous other things. And then, and I also, at the same time, continued to go to college. And I did that part-time, where I eventually got a bachelor's degree of science in psychology with highest honors.
What institution was that from?
That was from Northeastern University.
And that was a Bachelor of Arts in Psychology?
I think it was a Bachelor of Science.
Got it. Subsequent to your Bachelor of Science degree from Northeastern, did you also advance your education further, formally?
Subsequent to, so yes, so I decided that I did want to pursue a medical career. And so I then attended medical school, University of Massachusetts Medical School, full-time for 4 years.
Did you ultimately get a degree, an MD degree from UMass?
Yes, a Doctor of Medicine degree in 1987.
So you were there from 1983 to 1987, is that right?
That is correct.
And did you do a residency?
I did 2 residencies, actually. Most people do 1, but I did 2. I did, my first residency was a combined internship and residency for 4 years. And I did that in Los Angeles at Los Angeles County Medical Center, which is a very big trauma center and what I would consider the Bellevue of the West Coast. Very busy.
You say that just because of the volume at USC Medical Center?
That is correct.
Is it one of the busiest medical trauma centers in the country?
Yes.
You were there from 1987 to 1991, is that right?
Yes, I did my ER internship and residency during those years. Yes, there.
During that time, were you seeing patients?
Oh, yes.
You were treating patients?
Lots of them.
You were attending to patients?
I was a trainee, so I was seeing as many patients as we could. There was always a waiting room full of patients, and yeah, so I saw many patients during that time period.
You indicated a second residency? Tell me about that.
Okay, so I still realized I had an interest in forensics, and so I decided that I wanted to also train in forensic pathology. So I did a second residency in anatomic pathology, 2 years, followed by forensic pathology fellowship at the Los Angeles County Coroner's Office for 2 years.
And the years, if that's 4 years, that would be from 1991 to 1995, approximately?
That is correct.
Tell me what your experience was as a fellow at the Los Angeles Coroner's Office, Los Angeles County Coroner's Office.
Yes, well, it also was a very busy coroner's office. And so every day there would be cases. I probably did at least 2 cases a day, most days, and plus conferences and educational opportunities. But the interesting thing about being a fellow is they try to give you a wide assortment of cases. So, for instance, I not only saw numerous victims of gunshot violence and stabbings, but I saw numerous victims of motor vehicle accidents and natural death, overdoses. And then if there was an unusual case, it usually went to the fellow, because the fellow was also being supervised. So,
did any of those unusual cases, and we'll get more into this in just a second, but did any of those unusual cases include animal attacks?
Yes.
Did you become a professor, an educator at any point?
Yes. So during my 29 years at LA County Hospital, during the last 25 of those, I was a assistant professor or an instructor, but mostly an assistant professor. And what that meant is that I was responsible for overseeing the care that was provided by the interns and residents. So when a patient would come into the hospital, the emergency room, were oftentimes usually seen by the intern or resident, and then I would go and subsequently see that patient also. So, and that was in addition to my own cases. So I'd see my cases and their cases.
And that was at LAUSC, correct?
That is correct. And
Can I ask a quick question?
Yes.
LAUSC, for those of us who are not necessarily familiar with it, is that associated with the University of Southern California Medical Center?
Yes.
That's the school, in other words, the site.
Yes, so it stands for Los Angeles County / University of Southern California Medical Center.
And that's where you were an assistant professor for the majority of the rest of your career?
Correct.
Were you also an assistant or an adjunct professor at Cal State Los Angeles?
Yes.
Okay. For how long were you an adjunct professor there?
I believe that was 4 or 5 years. And I taught criminalistics, forensic medicine there.
As an attending physician in the ER, in other words, a supervising physician in the ER, can you tell us what some of your duties and responsibilities included, especially as it pertains to trauma? And then I'll get more specific in just a second.
Okay. Well, so I would oversee the care of all the patients that came in during a particular shift. And that would include medical patients and trauma patients. And as I mentioned, it was a very busy trauma center. So we had lots of trauma patients, including the types of violence I described earlier that I saw at the coroner's office, but lots of motor vehicle accident victims because there was a highway there right nearby. There were a couple of highways, so a wide variety of accidents.
Did your supervision include assessing, diagnosing, and treating patients?
Correct.
In terms of the middle part of that, diagnosis, was part of your job to determine the cause of injuries or to at least assess the cause of injuries?
Yes, and I took that on a little bit more because I was interested in the forensics aspect of the injuries.
The forensic aspect?
Yes.
Okay. During your time at LAUSC, even after you left the Los Angeles coroner's office as a fellow, did you continue to stay in contact with the coroner's office and have relationship with the coroner's office as a supervising physician?
I continued to stay in contact with the coroner's office, and I used to attend their conferences as often as I could, not as a supervising physician, but as a physician and a graduate of their program.
During your tenure at LAUSC, did you ever become the director of any programs at LAUSC?
Yes.
Does that include the director of Center for Life Support Training?
Yes.
What years was that, if you remember?
I don't remember that.
The early 2000s, late 90s?
Yes, that sounds about right.
Okay.
And we would conduct lots of courses, including trauma, life support courses.
Did LAUSC incorporate a quality improvement program?
Yes.
Within their institution?
Yes.
Did you become a director of that as well?
Yes.
So you were director of Center for Life Support Training and director of LAUSC Medical Center Quality Improvement, is that right?
The quality improvement was for the emergency department. Yes.
And did you also become the director for jail medical services?
Yes.
What is the association between LAUSC and the very, very expansive jail system in Los Angeles County?
So LA County Hospital was unique in that they, many, many years ago, developed a jail, what they called a jail ward, which was a combined inpatient, outpatient, and ER. So there was a dedicated jail ER. And that has been in existence for probably about 70 years now. And patients that were placed under arrest by either LA sheriffs, LAPD, California Highway Patrol, or any of the municipal agencies in the area, and I think there were about 70 or more municipal agencies, could bring their patient to the LA County jail ward where the patients would get treatment.
Ultimately, you became the director of that entire program, correct?
Yes.
Did you also work with the State Medical Board of California in any capacity?
Yes.
Tell us about that.
For about 7 years, I worked part-time for the California Medical Board as a physician assigned to one of their enforcement teams. And I did that 1 day a week, and I did my other job at the county hospital the other 40 hours a week.
So you didn't take off time from your duties as an ER physician, as an emergency physician. This was in addition to you being an emergency physician.
That is correct.
Did you hold the title of Chief Medical Executive for the California State Prison System, specifically at Corcoran?
Yes.
Tell us about that.
So I retired from LA County Hospital, and I went on to move on to the the California Department of Corrections and Rehabilitation.
And what year was that? Did you make that transition?
So 2018 is when I started for the state prison system.
Okay.
And I worked there for 5 years as director of their medical service in Corcoran.
I'm sorry. So for that prison, within that system, you were the chief medical executive for the entire agency, correct?
That is correct.
All right.
For the entire prison.
Understood. Are you board certified in emergency medicine?
Yes.
Are you a member of the National Association of Medical Examiners?
Yes.
Are you a member of the American Academy of Forensic Science?
Yes.
Do you have any publications in the area? And I'm going to be very specific because you've been relatively widely published. Is that right?
Some people would say yes. Some people would say no.
More than a couple of publications.
Correct.
And peer-reviewed journals, correct?
Yes.
I want to focus your attention on animal injuries. Have you been published in the area of animal injuries specifically?
Yes.
Do you recall those publications?
Yes, they had to do with law enforcement dog bites.
Did you draft an article or co-author an article called Managing Law Enforcement Dog Bites in the ER?
Yes, I was a co-author.
1996?
Sounds right.
And that was a peer-reviewed article?
Yes.
Ultimately published?
Yes.
And ultimately available to be cited by other doctors and studied by other doctors, correct?
Correct.
Did you also author or co-author an article entitled Law Enforcement Canine Dog Bites, Injuries, Complications, and Trends?
Yes, I did.
Was that in 1997?
Sounds right.
Was that also peer-reviewed?
Yes.
And that publication was also available for other physicians throughout California and throughout the country to refer to for the study of animal bites and dog bites, correct?
Dog bites, yes.
Dog bites. Concerning animal injuries, during the course of your professional experience, how many patients have you seen, diagnosed, and or treated with animal injuries, including dog bites and scratches, if you had to estimate?
Many hundreds.
Would you say it's over or under 1,000?
I would say it's over 500. I don't know because we didn't keep really good records back in the earlier days.
But it's safe to say you've seen hundreds and hundreds and hundreds of dog bites and scratches.
Yes, in my 29 years at LA County Hospital, yes. And my dog bites I took care of and dog bites that the residents took care of, yes.
And you've even published articles and studied, not just seen them, but studied dog bites and dog wounds, correct?
Yes.
Have you qualified as an expert previously in other courts as in emergency medicine?
Yes.
Have you qualified as an expert in other courts in forensic pathology and wounds?
Yes.
Has that been in both state and federal court?
Yes.
Doctor, were you asked to review certain materials related to this case?
Yes.
And that was in furtherance of coming to, if you could, come to an opinion or a conclusion about injuries to the victim in this case, a person by the name of John O'Keefe.
Yes.
What did you review in anticipation of your determining whether or not you could come to an opinion or a conclusion?
So I reviewed hospital photographs, autopsy photographs, an autopsy report, grand jury testimony from the medical examiner in this case. There may be some other
based on
items.
I just want to ask about that. Do you have notes with you as to what you reviewed?
No.
Okay, so when you say there might be other, you don't.
Well,
if he tells you what you reviewed, you'd know it.
I would recognize it.
All right, but I want to hear it from you. You don't know of anything else that you've reviewed? This is sort of important, Mr. Jackson.
Okay.
Can you think of anything else, Doctor,
The
besides
autopsy.
these?
Autopsy photographs, autopsy report, neuropathology report, toxicology report, and the grand jury testimony.
Okay, so as you recall, the items that you reviewed include an autopsy report by Dr. Scortibello, correct?
Yes.
A neuropathology report by a doctor named Stonebridge, correct?
Yes.
Toxicological reports associated with the autopsy?
Yes.
Grand jury transcripts from Dr. Scortibello?
Yes.
Photographs of evidence items, including a gray sweatshirt?
Oh, yes. Yes.
And autopsy photos that were taken attendant to the actual autopsy?
Yes, and photographs that were taken in the hospital, and I reviewed the hospital ER record also.
So in addition to what you just listed, there's also hospital photos separate and apart from the autopsy photos, is that correct?
Yes.
And those hospital photos showed the injuries to Mr. O'Keefe's arm, is that right?
Yes.
And you also reviewed emergency room records that are attendant to his initial acceptance into the emergency room on January 29th, 2022, correct?
That's correct.
Based on your review of all of those materials, were you able to confidently come to any conclusions or opinions about the nature of the injuries suffered by John O'Keefe, specifically as they relate to John O'Keefe's right arm?
Yes.
What is your opinion and conclusion concerning those injuries?
Those injuries appear to be consistent with an animal attack.
Can you be more specific in terms of the type of animal, or are you relegated to simply an animal attack?
Well, they are consistent with a large dog attack. There's a combination of both what I consider bite wounds and scratch wounds on the arm. There were also some puncture wounds in that shirt.
And are
So I'm sorry, puncture wounds in the shirt?
Puncture holes in the shirt.
And on what do you base the opinion that the injuries are consistent with dog bite or scratch marks?
Well, the patterns. There are several patterns of parallel wounds that appear to be superficial scratches that could have been caused by nails or could have been caused by teeth. There are different angles on the arm and different locations on the arm, and but they're generally oriented in a specific direction. And there's also an area, the distal forearm, which is close to the wrist, which shows what I believe is an arch area of teeth marks.
And what's the significance of the arch area?
Well, so the arch would be the front area of the jaw of the animal, you know, or the dog in this case, where the teeth tend to be close together and curved. There's a curved pattern to the configuration of the teeth.
Let me have just a moment, Your Honor.
Yes.
Doctor, I want to show you a series of photographs. May I approach you?
Yes.
First, can you describe whether or not you recognize what's depicted in that photograph? Have you seen that photograph before?
Yes, I have.
Is that part of what you reviewed in coming to your opinions and conclusions?
Yes.
What is that a photograph of?
So this is a photograph of the decedent's arm near the elbow. And do you want me to describe what it shows?
Just briefly, an
Okay.
overview of what
Yeah, and it shows wounds.
Okay. Your Honor, I would ask that that be marked as next in order of evidence.
All right, so for this voir dire, we'll have separate evidence, right? Is this an exhibit number in the trial already?
It has not been marked yet, so I'm fine with starting over, sort of for the purposes of the voir dire process. How are the purposes to do it?
So this will be a separate voir dire with separate exhibit, yes.
So it's going to be exhibit 1?
Yes.
Your Honor, I want to move this along. This has been marked, but I think...
Hold on. Okay.
I'm so sorry.
No, go ahead.
This one of the three has already been marked, but if, just for consistency, I'd rather mark it additionally for voir dire. Yes.
Need a separate record for the voir dire.
May I approach?
Yes.
This one's already been marked, but I'll remark it.
And if you'd tell me the exhibit numbers that they are. So you're putting these in now? There's no objection, Mr. Lally?
For purposes of this, no.
Okay. So we'll mark these now, but
May I approach?
yes.
The one with the label 2858 on the bottom has previously been marked in the trial. I would ask that this be marked as the next in order for the voir dire.
But what I want is the exhibit number at the trial.
Oh, I'll get that for you. I believe it's exhibit 19.
Okay?
Sounds like these are hospital pictures instead of autopsy
19?
pictures.
That's correct. It's 19.
The difference might be the amount of cleanup that's been done onto the wound. So these might be a slight.
And is the third one also in evidence, you said?
2 of the 3 have not been marked. I'll as soon as Madam Court reporter is ready.
She's ready.
I'm ready. May I just establish the foundation?
Yes.
The following 2 photographs that I just showed you, Doctor, do you recognize those?
Yes.
Did you also review those in terms of, in furtherance of coming to your opinions and conclusions?
Yes.
Do they also appear to be different photographs of John O'Keefe's arm?
Yes.
I would move for the admission of both of those, Your Honor, for purposes of voir dire.
There's been no objection to them, so they're in. They're already marked.
I just need to know which one's 2 and which one's 3. May I approach?
Yes.
Okay, that's.
Lots of sighs from the judge today.
Permission, may I publish
Yes.
Exhibit 2 for voir dire?
Yes.
She doesn't like this. Judge is not happy today. When judge isn't happy, nobody's happy.
Is this a photograph of of John O'Keefe's arm?
Yes.
Is this one of the several photographs that you reviewed in coming to your opinions and conclusions?
Yes.
I want to ask you a couple of questions about this. There should be a laser pointer on the desk.
Oh, okay.
Can you explain for the jurors what it is about the injuries that assisted you in coming to your opinion and conclusion that this is from an animal attack?
Okay, there's several patterns here. So, for instance, let's look here, right near the elbow, the exterior part of the elbow. There's these 2 linear marks, which appear to be from upper teeth, and 2 punctures below those, which are superficial meaning they didn't go very deep into the skin, but they appear from the lower teeth. So that's one pattern.
So that's one bite mark.
There's another pattern close to the shoulder, which shows parallel marks, these two, and maybe a third one in the middle, parallel marks that are oriented at a certain angle. And these are superficial wounds, which are consistent with teeth marks. They also could be possibly consistent with nail marks, but
With what?
a nail from claw, yes.
All right.
We
Wouldn't
have
the
some
middle
more
one be
here, similar from obviously different teeth involved or different claws, and then down here, closer to the wrist, we have an unusual pattern of at least 4 striations, the way I see it, at least 4 striations that I believe are caused from the teeth towards the front of the mouth, near the arch. It appears that there's an arch pattern here. So,
In a dog attack or in an animal attack, in your experience, and we can take this one down. Let's cover the ground on the 3 exhibits that we've already marked. Can we take a look at Exhibit 1? Is this just a may I publish, Your Honor? Yes. I apologize. Is this just a close-up of the same injuries?
yes,
And do these appear to be consistent with what you just testified to in terms of either teeth or claw marks, especially as it relates to the area closest to the elbow?
yes.
All right. And then looking at Exhibit 3.
That would make the bottom teeth be 1.5 centimeters apart.
May I publish?
Yes.
Is this a close-up view of the area closer to the wrist that indicated those parallel, you used the word
I
striations?
think this might vindicate
Yes.
All right, and
Chloe.
these appear to be taken, attended to the autopsy as opposed to the other photograph, Exhibit 2,
But
that was taken in the hospital. Is that
a
right?
possum.
That is correct.
All right. And would the time difference account for the slight change in the nature of the wound?
It could.
Photograph of the wound, I guess?
It could, or a different technique, yes.
Okay. Let me take these down. Did you take into consideration the lack, in coming to your opinion and conclusion, the lack of other injuries, for instance, fractures, broken bones, or deep bruising, soft tissue injuries?
Oh, yes.
How did that play into your opinion?
Well, so of course I considered, what else could have caused these wounds, before coming to my conclusion. And so I wanted to rule out other things. And there were no significant major bodily injuries outside the head. There was nothing, there were no fractures of the long bones, the chest, the pelvis, the arms. So yeah, so having seen hundreds and hundreds of car accident victims and people hit by cars, I ruled that out very quickly.
Okay. And in terms of the injuries that you did see, especially as they're attended to the arm, based on everything that we've discussed today, is it your opinion, based on a reasonable degree of scientific certainty, that those injuries are consistent with an animal attack as opposed to a motor vehicular pedestrian incident?
Yes.
Thank you. That's all I have.
Interesting. She rules out
All right,
the
Mr.
car
Lally.
crash possibility as the cause of those injuries because of the lack of bruising. She seems to have enough experience with car crashes to
Good morning, ma'am.
understand
Good
that.
morning.
Let's see what Lally does. He's got
You were
free
talking
reign
about,
here. He
some
can go wherever he wants.
police training that you had received when you were in the academy or while you were working with the police department here in Massachusetts. Is that right?
Yes.
Okay. What kind of training or what did that training consist of?
Well, I attended and graduated from the Standard Police Academy at that time. And then I took additional courses that were offered from the Massachusetts Criminal Justice Training Council. And these were taught generally by experts in their fields, and they were on a variety of subjects that are listed in, in my CV, included, the hit and run accident investigation, forensic.
There just for a minute, ma'am. Doctor, in reference to your training as it pertains to hit and run accidents, what did that training consist of?
Oh, well, mechanisms of how accidents occur, mechanisms of how to determine, what vehicle was involved in an accident. I don't, it was a long, long time ago, but yeah. So determining if people were struck by vehicles, what vehicle was involved, or if there was auto versus auto accident, what vehicles were involved.
And I don't mean to belittle this training whatsoever, but is it fair to say that that was relatively rudimentary training that you received in the academy?
Probably. I would not, yes, okay, probably. If
You don't have any training in crash reconstruction or anything like that, correct?
That is correct.
And am I correct in you indicated that you're board certified in emergency medicine, is that right?
That's correct.
And so you're not board certified in forensic pathology or anatomical pathology or any kind of pathology?
That's correct.
And the last time that you worked as a coroner, when was that?
The last time was in 1995 when I was doing autopsies for the coroner's office. I have since, though, consulted on some cases from the LA coroner's office.
What, about 30 years ago? Is that about right?
For autopsy, yes.
Now, have you ever testified in a case in which either Mr. Jackson or Attorney Little were counsel?
Not that I'm aware of, no.
And when was it that you first were contacted in reference to this case?
The first contact was May 15th.
May 15th of what year?
May 17th, excuse me, of this year, 2024. Yes.
And you went through a list of things that you were provided and you reviewed, and you mentioned hospital photos, correct?
Yes.
Autopsy photos, is that correct?
Yes.
An autopsy report, is that correct?
Yes.
Grand jury testimony from the medical examiner, is that correct?
Yes.
A neuropathology report, is that correct?
Yes.
A toxicology report, is that correct?
Yes.
And then I think you also remembered some photos of some clothing items, is that correct as well?
Yes, a shirt. And
anything else?
Yeah, hospital ER record.
Hospital ER records.
Yeah, yes.
Anything else that you can think of?
No.
Did you ask for anything else to review?
No.
Were you told of any other material that was available for your review that you weren't then given?
Well, I requested that that I focus in on the wounds, so I didn't ask for a lot of material in this case.
But fair to say that you were looking for anything and everything, material to the wounds that you were asked to look at, correct?
Please say that again.
Sure. Fair to say that you would want to look at anything and everything that was related to the wounds that you were asked to look at, correct?
Yes.
And so, did you make any specific requests as to what material you were provided, or were you just handed some material or forwarded some material and you looked at what you were given?
No, I requested that I have the autopsy photographs, the ER records, the ER photographs. I requested those.
Now, you mentioned some articles that you had written that were published back in 1996 and 1997 related to dog bites, is that right?
Yes.
Are those publicly available articles?
Yes.
And in those articles that you wrote, you were talking about law enforcement bites, correct?
Yes.
So law enforcement canine bites typically involve what people call sort of a bite and hold technique, is that correct?
Yes. Yes.
And so is there a difference between, through your experience and the hundreds of dog bites that you've seen, is there a difference between what you would observe from a dog bite from a law enforcement canine versus just your domesticated dog?
Well, yes. Now, the study, one of those studies was over 700 dog bite wounds, and there were two techniques used at that time: bite and hold, and later on, bark and hold, or bark and alert, or something of that nature. So there are different techniques, but yes, to specifically answer that question, which was, are they generally different from regular domestic dog bites? Yes.
Now, did you write a report in regard to your opinion that you testified to here today?
No.
Why not?
I don't think there was much time, and I didn't know if I was going to be actually testifying.
How long would it take you to write a report?
I wasn't asked to write a report, excuse me.
Were you asked specifically not to write a report?
No.
Now, at any point in time, did you ever look at anything related to Mr. O'Keefe's head injury?
Oh, yes.
So you reviewed reports in relation to that, correct?
Yes.
Do you have any opinions as it pertains to that?
I would rather defer to the pathologist and neuropathologist on that.
Interesting. No answer for the head injury.
So who contacted you about this case?
I contacted a district attorney that I had worked with in the past. We were discussing a different case, a case that I autopsied in 1995. And I mentioned that I heard that there was a case in Massachusetts that might have been being handled by one of his colleagues, his former colleagues, and that there was an issue of whether something was a dog bite, and that I might be able to help in that case, to clarify.
And so when you were provided this material, what is it that you were specifically asked to do?
To look at the wounds and the reports and the materials that were sent to me and render an opinion.
And so before you had even been provided any material, before you had even looked at anything, you had already heard information related to there being a dog bite involved in this case, correct?
I had heard that there was a controversy, that there's some certain wounds could have been a dog bite versus perhaps inflicted by a motor vehicle. That's what I had heard.
So, ma'am, what I'm really trying to get at, doctor, is sort of the timeline. Okay, so you hear about this. When was that?
Sometime just before May 17th.
So sometime just prior to that, you hear about some controversy in a case in Massachusetts involving a dog bite. On May 17th, you get reached out to by who specifically?
His name is John Lewin. He's an attorney in the LA District Attorney's Office.
And then who did you talk to after that?
I reached out to him. I said I might be able to clarify. And then he reached out to Mr. Jackson, I believe, and then Mr. Jackson contacted me.
And not asking specifically anything you spoke about, but at some point the discussion came specifically to dog bites, correct?
He sent me the materials. He asked me my opinion.
Sent you the materials, asked you your opinion. When did you provide that opinion?
Probably the next day. Yes, I know it was the next day.
So the very next day on May 18th, you provided an opinion?
Yes.
And was that opinion provided in a written fashion, orally? How was that provided?
Orally.
So you reached out to someone shortly before May 17th, spoke to Mr. Jackson on the 17th, received all the material, and then had an opinion by May 18th?
Yes.
But you didn't write any of that down?
No.
Now, beyond the materials that you were provided, what else were you told about the case?
I was told that the victim was a police officer. The decedent is a police officer. I was told that well, the defendant had been charged, and I was told that that there was a controversy about whether or not these injuries had been caused by a motor vehicle. And I was also told, and I read in the medical record, that the decedent was found outdoors, I believe in the snow, and hypothermic.
Now, in regard to what you reviewed, you didn't review any investigative reports, is that correct?
That is correct.
You didn't review any witness statements, is that correct?
That's correct.
You didn't review any lab reports as far as from the forensic lab or anything like that?
I reviewed the toxicology report.
Beyond that, any other?
If it was part of the autopsy report, I reviewed it.
So you reviewed everything attendant to the medical examiner's file, is that correct?
Yes.
But nothing from the lab beyond that?
I don't believe I did.
Now, this first instance when you say you heard about it, how did you hear about it?
Well, I believe it was via a headline that I received in my email from the from Boston Globe headline. You know, it was some kind of there was some kind of interesting case, and I got it as an email, and I looked into it.
And when was that?
Well, that was that week in May. That just a few days before May 17th.
You subscribed to the Boston Globe online?
I did at that time. I have not renewed it.
How long had you been a subscriber to the Boston Globe?
I'm going to allow it.
Probably a year or 6 months, 6 months to a year.
And there was never any headlines or anything else that you saw about this prior to that week just before May 17th?
Not that I paid attention to.
I have nothing further.
Interesting.
Anything further, Mr. Jackson?
Nothing further.
All right, so since this is a voir dire, I get to ask questions, Doctor?
Oh, yes,
I just have a couple of questions for you. I don't think I really heard you. So could you tell me again what your opinion is and to what degree you hold that opinion?
Professional certainty.
Yes. These injuries in the arm are, my opinion is that they are the result of animal bites or scratches.
And do you know what kind of animal?
Oh, yes, most likely dog, large dog. And I'm very reasonable, very sure to
degree of professional.
What's the word I want? Medical certainty. Very
All right,
high,
so
degree, high degree of medical certainty.
Reasonable degree of medical certainty.
Yes, definitely.
Okay, and another question. So I received information that you also viewed all reports associated with Chloe, a dog's prior bite history. Did you review those?
No, I don't recall ever seeing anything like that.
You also reviewed the UC Davis DNA testing results submission forms?
No, I don't recall seeing them.
Okay, any follow-up, any questions based on my questions?
Who told her she saw
Not for the Commonwealth, no.
No, Your Honor.
All right, you are all set, Doctor. I don't know yet whether you'll be testifying. Okay, well, we'll try and let you know. Are you going to be around for a few days?
No.
Okay, we'll let you know as soon as we can, okay?
Okay, okay.
Thank
All right,
you.
thank you.
For a few days? Nope. The judge doesn't like it. She doesn't like that she didn't have the right word to reasonable degree of medical certainty. She didn't like that. What was another word she messed up? She caught her on the wounds to the shirt. She called her out on that when everyone knew what she was talking about. I don't think the judge is fond of this being a witness. This doctor being a witness. Well, one of three down. Interesting how she found the case. It's important that that happened in that order because if they had sought her out.
So I would like to hear argument on this witness before we hear the other witnesses. So And Ms. Giannetti, I asked you the other day whether she reached out to you or you reached out to her, and you said there was an intermediary. But my concern was whether she came out of nowhere and reached out about this case, and that seems to sort of...
It wasn't Mr. Giannetti, it was me.
Okay. All right. So the question I asked was answered pretty much by this witness, whether she saw something and decided she wanted to come forward.
She came
All right,
forward out of nowhere.
it's the Commonwealth's motion. What are you asking me to do? Again, I found a violation of Rule 14. And there are two concerns here, the competency of the witness's testimony, how much she can testify to, whether she should testify at all. What is it you're asking me, Mr. Lally?
She's spoon-feeding.
Your Honor, I'm asking that the witness be excluded from testifying at the trial for the violation of Rule 14. Specifically, I believe it's Rule 14A6. This is a witness, as the court picked up on, that reached out, albeit through an intermediary, with reference to just sort of discovering or coming upon this case in several weeks into the trial. It is concerning, given the fact that the witness represented that she had a subscription to the Globe Online, received word of this, and the first time that she had ever seen it or it had grabbed her attention was in that first week of May when, as the court is well aware, there's been widespread media coverage, particularly through the Boston Globe, for years at this point. The limitations of the testimony, it's also concerning because the disclosure from counsel indicated, again, as the court had noted, I didn't want to get into too much as far as for purposes of this voir dire, but there was additional material that was indicated in the disclosure that the witness had reviewed, including the UC Davis related to the canine DNA or the lack thereof, as well as, forgive me, the dog bite history of that specific dog, which also, I would note for the court, includes photographs of what a dog bite from that specific dog looks like. And that specifically apparently was not provided to this witness, who's then opining on, inferably at least, that that dog was the cause of these particular injuries. However, was not shown specifically anything to do with that bite history as far as by way of reports or photographs. So that juxtaposed or coupled with the immensely late disclosure. I mean, we're talking about at least the 6th week of trial by the time this witness is even mentioned, not on the defendant's witness list, not mentioned at any point in time during the pendency of the case, and then sort of pops up in the middle of May, and to the point that the limited amount of material or information that's provided by counsel as far as disclosure or opinion doesn't come until today. So for all those reasons, Your Honor, the Commonwealth is requesting that her testimony in its entirety be excluded from this trial.
Mr. Jackson?
Your Honor, exclusion is the highest form of punishment. It's the highest form of sanction that the court has available to it. Just to put a fine point on it, it is a dire remedy. And I know the court has mentioned 2 or 3 times, I'm finding a violation of Rule 14. That sounds as if the court is suggesting or has inferred that we did something wrong. We didn't do anything wrong. As the court learned, I didn't reach out to her. She reached out and said, hey, look, I've got some experience with this.
I asked you that the other day, though, and I was told that you reached out to her through an intermediary. I wasn't told she reached out to you through an intermediary.
I don't know that there's a difference. I mean,
what I was trying to get at, is this somebody who read about this case and said, you know, I want to be part of that? That's what I was trying to get at. I think it was pretty clear, Mr. Jackson. Go ahead, continue with your argument.
okay, I did not misrepresent anything to the court.
I didn't say that.
I take offense at the court's tone. Yes, you did say that. You just said that. You said,
Okay.
I just heard the testimony, and it's not what I said the other day. I know a person in Los Angeles DA's office. I received a text message from that person saying there's someone who reached out to me who said I might be able to elucidate on this controversy concerning the dog bites. I then reached out to her. So when you asked me who reached out to whom, I reached out to her through an intermediary, my friend in the DA's office back in Los Angeles County. I wasn't missing.
So maybe it wasn't clear what I was looking for. I think it was clear, but go ahead, continue with your argument on this.
My point is, Rule 14 requires a sanction if, in fact, the attorney has done something wrong. In other words, it connotes the idea that we're doing something by actively hiding evidence or holding back evidence or not providing evidence that you know you're going to use at some point in an effort to take a tactical advantage. And the sanction for that is exclusion. I've never met this woman. First time I laid eyes on her was during the process after she flew out here to engage this voir dire process. She indicated I could potentially provide some information about this controversy concerning dog bites. I then sent her materials. I talked to her. I sent her materials. I found her to be incredibly credible. I found her to be experienced. And I found her to be knowledgeable in this very specific area, which is rare. There's not that many people who have published, doctors who have published in the area of dog bites specifically. So I thought it makes sense for me to reach out to her and talk to her, which is exactly what we did. And within a couple of days, literally, you could almost count it by the hours of me receiving her information, we then had a discussion amongst ourselves. Is this somebody that we want to then present on the defense side, on the defense case, and we turned the information over to Mr. Lally. I understand that it was well into the trial, but that's not a fault of ours, and I don't think the sanction of exclusion is necessary or appropriate to punish Ms. Reed from having an experienced witness testify in rebuttal to ultimately what Dr. Scorti-Bello and the Commonwealth is going to present in their case in chief. That's what she's going to do. She's going to present contrary evidence or an alternative theory of where those injuries came from to a person. Everybody on the Commonwealth side who can elucidate about this has said those injuries come from a taillight, including Mr. Paul yesterday. We have contrary evidence, and Ms. Reed should be entitled to present that evidence, even though it came late. It didn't come late by any fault of ours, and I don't believe that the Commonwealth has made out a prejudice that they can't overcome. It's late. Obviously, Mr. Lally is a skilled lawyer. There's nothing to say that he can't or hasn't been able to prepare for the cross-examination or for an examination in front of the jury, and I just don't think exclusion is appropriate.
All right, so the second part of this argument, and I'll start with the Commonwealth first. So in your motion to exclude, you also raise Daubert-type concerns. So,
not Dilbert.
Mr. Lally, is there portions, if I permit her to testify, are there portions focused specifically on the part of her opinion where she says
she's fishing for emotion?
I guess the defense expects her to be able to say she will testify that these injuries are inconsistent with having been struck by a vehicle, road rash, or scratches from broken glass or tail-like material.
She's spoon-feeding Mr. Lally the lines.
I think you have an uphill battle on that part, Mr. Jackson. But Commonwealth, what are you saying? If she testifies, what should she be able to testify to? And don't just say nothing. I want some input.
No. If the court were permitted to test the doctor to testify, Your Honor, what I would submit would be permissible testimony from a legal standpoint, as some factual questions in regard to that. But from a legal standpoint, I think the court could permit her to testify as to the injuries that she observed, her work and history in that area, observing prior injuries related to animal attacks and whatever consistency she believes that they have with that. I do not think it would be proper to allow this witness to testify or opine anything about the inconsistency with regard to pedestrian injuries. I don't think any proper foundation has been laid for there, whether it be through experiential knowledge in relation to that, or any sort of specialized training or knowledge, or anything to do with that. Anything from a forensic pathology or anatomical pathology perspective, I think should also be out of bounds and excluded with regard to this witness. She's certainly a very experienced emergency room physician. So anything in relation to that, I think it's permissible, but as far as the experience when it comes to motor vehicle crashes or pedestrian crashes, of which the court is well aware, there are a litany of different types of interactions a pedestrian can have with a motor vehicle in a collision sequence. And simply saying, well, there was no injuries to the leg, so it couldn't have been a motor vehicle collision is just plain wrong, and not backed up by science or anything else that this witness can testify to from the very limited experience she has in that realm. So if the witness were able or permitted by the court to testify, I would submit that her testimony should be relegated to simply what, if any, opinions, her experience, obviously, and then what, if any, opinions she draws with regard to the causation of the injuries on the right arm, as it pertains to consistency there. But I venture to guess that it's likely that those are probably also going to be, in her opinion, consistent with many other causes beyond that, if she's being reasonable.
Well, I just gave it the magic word,
All right, Mr. Jackson.
Which the judge whispered into his ear.
I'll submit, Your Honor. I
that.
have no issue with, I just said I'll submit, I'm not submitting. I have no issue with limiting her testimony to the animal attack issue, the dog attack issue. I didn't, as the court noted, I didn't spend any time. I think I may have asked one question that's consistent with the
There was one
motor
question.
vehicle incident. I have no problem if the court wants to limit her testimony to the dog bite aspect and not the motor vehicle aspect. I wasn't planning on going into that aspect anyway, because I've got another pathologist who's going to do exactly that.
But you did go through it with her, and it's on your disclosure.
Yep.
It is, but I have no problem editing.
So why is it on the disclosure, or where the Commonwealth turned over, that she viewed all reports associated with Chloe's bite history and the UC Davis DNA testing? Why is that in there?
Because we sent that in a Dropbox. We sent everything in a Dropbox, and I assumed that she reviewed it. She must not have seen it or opened it or reviewed it. I didn't know. But that's what was sent to her. Everything that's in the disclosure is what was sent to her.
All right. If she's permitted to testify, you led her through quite a bit. Today, you won't be able to. I mean, she struggled with to what degree of certainty she held an opinion. She struggled to what she viewed. She didn't write a report. I have to consider all of these things, too, as the gatekeeper, as to whether she can actually assist the jury. So I'm not deciding this right here. Mr. Lally, if I do permit her to testify, I will give you time to absorb this testimony and to find an expert in rebuttal for this. How long might something like that take?
Not terribly long, Your Honor. As far as preparation, I can't give an exact time frame on that. As far as a rebuttal witness, I'd say a week at the most.
A week from today?
Yes.
Why don't you start looking at least? All right, well, I decide I won't know until Thursday.
Sure.
All right. All right, anything else on this witness?
Submitted, Your Honor.
Okay. All right, next witness, please.
With regard to Dr. Wolf and Dr. Rentschler, this is a different scenario, and I'm presuming that the court is asking for a what year on their qualifications.
Well, I want to know who did what. I want to know, they say we. I want to know who did what.
Is the court suggesting that I go through their entire testimony of exactly what they did, their testing, their opinions, conclusions, the bases of their opinions, conclusions?
However you want to do it, Mr. Jackson, we're here today on the Commonwealth's motion.
I realize that, but it's not the Commonwealth's motion to depose our experts. The Commonwealth's motion is they're not qualified as accident reconstructionists. I don't need to go, and I'm not inclined to give them a free bite at the apple to cross-examine these witnesses twice on the basis of their opinion. I will go through, I think, to the court's satisfaction. I don't think it's going to take long to figure out that they're extraordinarily qualified to render opinions. But I don't think it's incumbent upon me to walk
do a
through their
quick
entire
test.
testimony.
It's gonna jump
and
a little
give the
bit, okay.
Commonwealth a free bite at the apple like it's a deposition.
Whatever you want
Free
to,
bite at the apple like it's a deposition.
whatever you want to do. I'm not telling you what to do. Whatever you want to do.
Okay, I'm just testing. We've got some ability to do live noise reduction. I want to see if it works better. The coloring's a little different.
Move your leg, please.
Did somebody say move your leg, please? Get your feet out of my walkway, or you shall be tread upon.
So we're going to be able to give the court the case now and hearing the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you.
Pull the seat in and just speak very loudly into the microphone.
Hello, sir.
Whenever you're ready, Mr. Jackson.
Thank you, Your Honor. Sir, could you please state your name and spell your last name for the record?
Daniel Wolfe, last name spelled W-O-L-F-E.
Sir, what do you do for a living?
I am the director of accident reconstruction at a company known as ARCA, A-R-C-C-A.
And tell us a little bit about ARCA. If you
He's
could explain
Mr.
to the
Paul's
court what
nightmare.
ARCA is and what its
Paul's
primary
nightmare.
mission is.
So ARCA is a forensic consulting engineering company. We have a variety of disciplines that include biomechanics, failure analysis, human factors, premise liability, crashworthiness, and accident reconstruction.
You said that you were the current director of accident reconstruction, correct?
That is correct.
Is that a specialty of ARCA specifically?
Yes, sir.
And what sort of contracts does ARCA routinely engage in?
We typically work for law firms, insurance carriers.
What about other clientele? For instance, maybe it's an insurance carrier or a law firm, but what about the ultimate client, the military, Department of Defense? Have you contracted with other entities or agencies, sporting agencies?
Certainly, yes. We've done research for the military. We do player safety for the NHL. So yes, we are involved in a number of research projects as well.
And in terms of ARCA and its commissions and consultation, is it known both nationally and internationally? Is it recognized as a leader in the area of accident reconstruction?
Yes.
As the director of accident reconstruction, do you specialize in not only accident reconstruction, but human factors as well?
Yes, sir.
Can you give me a synopsis of the professional discipline of accident reconstruction? What is accident reconstruction?
Well, I think that's a very broad topic. I look at the cases that come across my desk. You know, I've been involved with pedestrian impacts, and that can be pedestrians hitting the side of vehicles, fronts, backs, getting run over by vehicles, being struck by a vehicle, then projected into another vehicle. I've dealt with your simple fender bender collisions. I've dealt with collisions that involve 60-car pileups on a highway. So again, accident reconstruction in terms of the scope for a case, it can really vary case to case depending on the facts and circumstances of that case.
And when you say dealt with, are you talking about literally going into, from an engineering and a scientific standpoint, trying to reconstruct what happened, what the causal effects were of that accident, and what the results were, the resultant damage or injuries were?
Absolutely.
What about human factors? What does that discipline entail? What is human factors?
Well, to give you an example of that, so I do a lot of nighttime visibility work where, for instance, let's say a pedestrian's coming out onto the roadway at night. Maybe it's not a lit roadway and you're relying on your vehicle headlights to illuminate that pedestrian. So it's determining when would a driver recognize that individual on the roadway based upon the headlights, if there is any artificial lighting, their clothing. And then we look at how do drivers respond based upon that scenario that they're presented with. So we know that response times are different depending on the hazard that's presented to them. So if it's a pedestrian coming to the roadway, it's a vehicle stopping in front of you. So that's the application of human factors.
And that might include everything from passenger vehicles, commercial vehicles, bicycle issues, motorcycle issues, things of that nature.
Yes, sir.
Okay. What education, training, and background qualifies you to perform the duties that you just described as director of accident reconstruction at ARCA?
In terms of my educational background, I received a Bachelor of Science in Engineering from James Madison University back in 2012, along with a minor in mathematics. Some of my coursework while at James Madison Included courses in physics, statics, dynamics, kinematics, material science, and your typical engineering sciences.
Just the easy stuff.
Subsequent to my undergraduate degree, I then went on to the University of Delaware to pursue my PhD in electrical and computer engineering with a concentration in electromagnetics and photonics.
Did your research area also include physics?
Yes.
In addition to electromagnetics?
Yes, sir.
Optics?
Yes, sir.
Photonics?
Yes, sir.
And lighting?
Correct.
Are you accredited as a traffic accident reconstructionist?
Yes, sir.
I can look at lights.
By an organization known as ACTAR, which is the Accreditation Commission for Traffic Accident Reconstructionists.
Are you trained in photogrammetry to determine vehicle crash and map scene evidence from photographs?
Yes, sir.
In other words, looking at a photograph rather than being at the scene, that is a specialty or a specific area of training that you've engaged, correct?
Yes, sir.
Are you trained in Bosch crash data retrieval analysis?
Yes, sir.
Otherwise known as CDR analysis, right?
Correct.
In terms of professional associations and accreditations, are you certified by the Society of Automotive Engineers?
Yes, I'm a member of that organization.
What about being a member of Optical Society of America?
Yes, sir.
Illuminating Engineering Society?
Yes, sir.
And finally, the National Association of Professional Accident Reconstruction Specialists.
Yes, sir.
You're accredited by all of those organizations, is that right?
I'm a member of all of those. Yes, sir.
Have you authored peer-reviewed articles in the area that we've just discussed?
I've authored a number of papers in the field of physics, and one of my most recent publications was that dealing with Toyota and Lexus vehicle control history records.
In 2021, did you author or co-author a peer-reviewed article known as Collision, the International Compendium for Crash Research Dealing with Vehicle Control History and Braking Issues?
Yes, sir.
Have you qualified in other courts to testify as an expert in the area of accident reconstruction?
Yes, sir.
Importantly, were you hired by the defense in this case?
No, sir.
Before this morning, when you walked into court, have you and I ever met face-to-face?
No, sir.
In terms of the commission that you were asked to undertake in this case, that have anything to do with the defense?
No, sir.
That have anything to do with the Commonwealth?
No, sir.
So a third-party agency hired you and commissioned you, or ARCA, with the responsibility of doing an accident reconstruction in this case, correct?
Correct.
The person to my left, the female to my left sitting here, you ever seen her before?
Nope.
Do you know who she is?
Yes.
How many times have you been qualified in other courts to testify as an expert in the area of accident reconstruction?
I think that's around 20 times to date.
In both federal and state court?
Just state court.
Multiple states?
Yes, sir.
Your analysis, conclusions, and opinions are completely independent, whatever they are. Those analysis, conclusions, and opinions in this case are completely independent of the defense and of the Commonwealth. Have I got that right?
It's based on the evidence. That's correct.
And you're not paid by either side here in this courtroom?
He's
correct.
subpoenaed. They have the best expert in the country.
You and your
He's
team
here for
were asked
free.
to undertake a review for purposes of accident reconstruction of the case that's now pending before the court. Is that right?
That's correct.
Who at ARCA was assigned to the team who ultimately would undertake that analysis?
So it was myself, Dr. Andrew Rentschler, and Scott Klein.
And Scott Klein has a Master of Science, is that right?
I believe he's got a Bachelor of Science in Mechanical Engineering, yes.
In engineering?
Correct.
All right. And Dr. Rentschler is a PhD in what area?
Biomechanical engineering.
All right.
Smart people.
Were you provided and did you review certain materials in furtherance of your consultation in this matter?
Yes, sir.
I can have just a moment, Your Honor.
Yes.
I'd like to use my time efficiently, Doctor. I'm going to read through a number of materials that you reviewed. Before I do that, may I approach, Your Honor?
Yes.
I just want you to take a look at the first 2 pages of that document and tell me if you recognize that.
Yes, sir.
What is that? What are those 2 pages?
These are the first 2 pages from the report that ARCA issued in regards to this matter.
Do you see a list of 14 items on those 2 pages?
Yes, sir.
Is that an accurate reflection of the items that you were provided by this other agency to review in terms of coming to your opinions and conclusions concerning this case?
Yes, sir.
May I approach, Your Honor?
Yes.
Hired by an outside agency, not paid by defense.
Those items include
or the Commonwealth.
the Norfolk SPDU homicide death report, correct?
Correct.
The Commonwealth of Massachusetts Department of State Police crime scene report, correct?
Correct.
The OCME dispatch removal report, correct?
Correct.
Photographs of the incident location.
Correct.
Videos of the incident location.
Correct.
Photographs of the 2021 Lexus LX 570.
Correct.
Photographs of recovered evidence.
Correct.
Crash data retrieval report from the 2021 Lexus 570.
Correct.
Report of autopsy.
Correct.
Autopsy photographs.
Yes.
3-dimensional laser scan data of a Lexus LX 570.
Yes.
A VIN-Link, VIN capital LINK report sheet for the 2021 Lexus LX 570.
Yes.
Expert AutoStats data sheets for a 2021 Lexus LX 570.
Yes.
And publicly available literature, including but not limited to the documents cited within the report, learned treatises, textbooks, and scientific standards, correct?
Correct.
All of those items and data were reviewed by you and your team in coming to your conclusions and opinions in this case, correct?
Yes, sir.
And I'd like to ask you one other series of questions concerning sort of who did what. Your report indicates that there were, in no small part, 2 undertakings, if I can ask them in terms of pillars. The damage to the vehicle and the injuries to the body of John O'Keefe, correct?
I would say that's a fair characterization, yes.
Okay. And I may be butchering this a bit because I'm not being very scientific, but were you more responsible for the vehicle damage or the injury damage?
The vehicle damage.
And who on your team was more responsible for the injury damage?
That would be Dr. Andrew Rentschler.
Obviously, Dr. Wolf, in coming to your opinions and conclusions concerning the damage to the vehicle, you had to consider the damage to the human being, correct, John O'Keefe?
Correct.
And as the team leader, in terms of Dr. Rentschler coming to his conclusions and opinions concerning the damage to the human being, he also had to consider the damage to the vehicle and the interplay of the two, correct?
Correct. We work together.
I was just going to say, is that how you two and Mr. Klein worked together to come to the opinions and conclusions that are cited in your multi-page report?
Yes, sir.
Thank you. That's all I have, Your Honor.
Okay.
Wow, Lally,
Mr. Lally?
you're up. Good luck.
Thank you, Your Honor.
Sure you don't want to call in Mr. Trooper Paul?
Good morning.
To straighten everything out for you?
Now, you went through a list of about 14 things that are contained within your report that your firm or your agency was provided with that you reviewed, correct?
That is correct.
Did you specifically review all 14 of those things, or was that done as sort of a team?
Yes, I looked through all of the documents.
So you personally looked at all 14 of those items that are listed within the report?
Yes, sir.
And
oh man, swing and a miss.
You indicate that it was your opinions or what you did in this case. That was you were asked to answer specific questions, correct?
Yes.
It wasn't like you were just tasked with, hey, here's some facts, go do or take a look at a crash reconstruction or create a crash reconstruction. You were asked very specific questions and you tried to answer them the best you could, correct?
I don't know that there were specific questions. I think ultimately it was an open-ended question.
But related to you testified as to 2 specific areas that your firm or your agency looked at, right?
Those are the disciplines that the report covers, yes.
Well, you testified about some other areas of expertise as far as human factors, visibility, luminescence, things like that. You didn't do any of those things here, correct?
Wasn't part of my scope in this case.
And the scope in your case, you indicate that it was based on the evidence, correct?
That is correct.
Now, to be fair, that's based on the evidence that you were provided, correct?
Correct.
So what did Mr. Klein do?
So as a part of the engagement with the entity that ultimately retained us in this, due to the confidentiality of it, only those who had access to the material to the file were allowed to review it and discuss it. And essentially, Scott Klein served as kind of another reconstruction expert to essentially bounce ideas off of and help with the review.
So for lack of a better term, sort of provided, let's say, sort of technical review of your work and Dr. Rentschler's work, is that correct?
I would say assist us with the analysis, yes.
Now, obviously, your firm or your agency issued a report in relation to what you did, correct?
That's correct.
And you've obviously had a time to review that report as far as what's contained in there factually, as well as conclusions and opinions, things of that nature?
Yes.
So is it your testimony that anything that has to do with anything factually, conclusions, opinions, or otherwise, in relation to the motor vehicle damage, those are your opinions, those are your conclusions, correct?
I would say that's fair, yes.
And again, based on the evidence that you were provided, correct?
Correct.
And so the facts or evidence or conclusions or opinions related to injuries to Mr. O'Keefe, that was Dr. or Mr. Rentschler's area, is that fair to say?
Dr. Rentschler, yes.
And again, that was based on the evidence or whatever he was providing, correct?
Correct.
Which would be the same materials that you had testified that you had reviewed, correct?
Correct.
I have nothing.
Anything further, Mr. Jackson? All right, so, Doctor, I just have one question for you. What specifically were you asked to do?
I'm sorry, Your Honor, I didn't hear the court.
What specifically were you asked to do?
So the agency that retained us gave us a selected quantity of file material related to this case, and essentially left it as an open-ended question. Ultimately, was the evidence consistent with a pedestrian interaction between Mr. John O'Keefe and the Lexus?
Okay, you said selected quantity of information. Who selected that information?
As far as I'm concerned, it would be the Department of Justice and the FBI.
All right, and they just gave you what they wanted to give you, as far as you know?
We had no say in what material was handed over to us.
It was the Department of Justice and the
All
FBI.
right. Thank you very much. Any questions based on
Them?
my questions?
Huh.
No, Your Honor.
Mr. Lally?
Just briefly.
It was the FBI. Oh, my goodness.
And I apologize for this. I'm just unaware. Is it Mr. Wolf or Dr. Wolf?
Dr. Wolf is fine.
To you, it's doctor.
So, Dr. Wolf, when you say that you were asked specifically whether or not the evidence, the limited scope that you were provided was consistent with a pedestrian collision, were you asked sort of in general terms as far as any type of pedestrian collision, or were you asked specifically as far as biomechanically could say the injury to the back of Mr. O'Keefe's head have been caused by contact with the vehicle? How open-ended was this question?
Again, I think it relates to, is the vehicle damage consistent with the pedestrian impact, and are the injuries consistent with the pedestrian impact?
And again, the whole panoply of injuries, is that correct?
I'm sorry, what was your question?
Let me rephrase. So did anybody specifically ask you to determine whether or not the injuries to the back of Mr. O'Keefe's head could have been caused by a motor vehicle?
I don't know that they asked us specifically. Again, they basically asked us to perform an accident reconstruction and biomechanical analysis and basically tell them our findings, and these are our findings.
Oh, wow. And in the materials that you reviewed, did you see anything in there of any sort of statement, suggestion, intimation, anything at all that suggested that the injuries or the fracture to the back of Mr. O'Keefe's head was caused by a motor vehicle?
In terms of direct contact?
Yes.
No, I don't believe so.
That helps the state.
Nothing further.
That's
Anything?
That's a secondary injury.
All right, Dr. Wolf, you are all set, sir.
Thank you.
Oh, wow. That is going to be some spicy testimony. I don't see why he would be excluded. There's no motion to exclude this witness, right? He's like, oh, who paid you to do this? The FBI, the Department of Justice. What an expert to have on your side for the defense. Wow. There's some issues that he does not address that I think are problematic in the case. But that is a powerhouse of a defense expert.
I'm just going to ask you to be mindful of the court and step up. You're going to remain standing.
You solemnly swear to the give the court in the case now and hearing the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Bring the chair close and the microphone moves up and down and speak up loud.
Gotcha.
All right, whenever you're ready, Mr. Jackson.
Thank you, Your Honor. Sir, could you please state your name and spell your last name for the record?
Certainly, Dr. Andrew John Rentschler, R-E-N-T-S-C-H-L-E-R.
Sir, what do you do for a living?
I am a biomechanical engineer and accident reconstructionist.
In what area of the country do you live in?
I live in Pittsburgh, Pennsylvania.
What is your title
I love this.
currently,
Oh my goodness.
at your company?
I am a vice president and director of biomechanics for the Midwest Division.
And what is the name of that company?
It's called ARCA LLC.
And what is the main mission of ARCA? What does ARCA do?
So ARCA is a engineering consulting company, and we have several different types of engineers, biomechanical engineers such as myself, accident reconstructionists, mechanical engineers. We look at crash worthiness, safety of vehicles, and other types of events. So we really do all types of work. We do litigation type work, as well as research and development for government and private entities as well.
Let me have just a moment, Your Honor.
Yes.
As long as this guy's CV checks out, he's coming in. There's no motion to exclude him. Same with the last witness, and I think their CV's checked out.
The professional discipline of injury causation biomechanics. What is that?
So injury causation biomechanics is really applying traditional engineering principles to the human body. So as a biomechanical engineer, I look at the response of the body to accelerations and forces and determine how an injury occurs. You know, an injury to the human body is just an engineering problem. For instance, a mechanical engineer might look at a piece of steel and you know the size of the steel and the shape of it, and if you apply a force in a certain direction, that steel will bend and eventually break. Well, we do the same thing, but we look at the human body. How much force do you have to apply, and how does that force have to be applied in what direction or manner to get a specific injury, whether it's a skull fracture, an intervertebral disc injury, a concussion. So we look at the response of the human body to different forces and accelerations in different types of settings. And ultimately, our hope is to help mitigate or prevent injuries, whether it's in a motor vehicle accident, sports setting, industrial setting, auto pedestrian impact, try and make products and environments safer for individuals.
And that's different from what medical doctors do, correct?
It is, yes, sir.
A little boy walks into an ER with a broken arm. The medical doctor wants to reset the arm and fix the arm, correct?
That's right, yes.
What does a biomechanical engineer want to learn about the broken arm?
We want to learn how that break or that fracture occurs. I always say that we kind of approach injuries from two different directions. You have an injury occur. After it occurs, moving forward, that's when the medical doctors get involved. They diagnose the injury, determine the best way to treat it, what's the prognosis. As a biomechanical engineer, I kind of take the reverse direction. We look at, here's the injury, here's what's diagnosed. Well, how did that injury occur? You know, how much force do you have to apply to cause that fracture? How did the bone have to be loaded? How did it bend to actually cause a specific type of fracture? So we really kind of approach the injury from two different directions.
Understood. And given that scientific approach, oftentimes you can come to conclusions and opinions, scientific conclusions and opinions about the causation of an injury, correct?
Absolutely. Yeah, and I mean, ultimately, that's what biomechanical engineering is how does an injury occur? Why did it occur? And in what type of setting did the injury actually occur? What type of loading and what type of kinematics do you need to have this injury actually occur?
Can you tell the court brief synopsis on the discipline of human factors. What part does that play in what you do for a living?
Well, human factors is a large part of it as well. I mean, from a biomechanical standpoint, we look at the body, we have to know anatomy, we have to know the makeup of the body, and then human factors plays a part of it as well, as how individuals respond or what their response is to different types of environments or reactions. It really all plays into looking at a specific event. How did someone react? How did their body move? How was the body loaded? There's all different types of factors that you have to apply. The human factors, kinematics, kinetics, biomechanical, musculoskeletal interactions. It's all these different factors that are really involved in performing an analysis to ultimately look at injury causation.
All the things that Trooper Paul didn't do.
Doctor, as the Director of Biomechanics and Human Factors at ARCA, what education, training, and background qualifies you to perform those duties?
Well, I got my Bachelor's of Science in Mechanical Engineering with a minor in Biomedical Engineering from Carnegie Mellon University in 1995. I then went on to get my Master's in Bioengineering and Biomechanics from the University of Pittsburgh in 2002. And then I got my PhD or my doctorate in Bioengineering and Biomechanics from the University of Pittsburgh in 2004.
So yeah, all the education.
Can you give us a brief work history up to and before ARCA?
Sure. So I got my my PhD in 2004, and then since then I've worked in the consulting field for biomechanics. I've worked for a company out in Davis, California for a while called Biomechanical Engineering Accident Reconstruction. I then joined another engineering company in Jacksonville, Florida for about 3 years called Chesapeake Engineering and Design. And I have now been with ARCA for approximately 16 and a half years.
And in those in those positions and in your position currently as a director at ARCA, do you specialize in research and analysis attendant to evaluating and studying the relationships between crash injuries, crash forces, human kinematics, and human tolerances?
I do. I mean, that's really what I do on a daily basis, whether it be in litigation type cases or the research and development we do for different companies or entities, or even internal research that we perform at ARCA.
Doctor, what professional associations and accreditations do you have?
I'm a member of the American Society for Mechanical Engineers, as well as the Society for Automotive Engineering. Yeah, with respect to biomechanical engineering, there's no actual professional licensure for biomechanical engineering. So a PhD or a doctorate's the highest degree you can have in that field.
Are you also a reviewer for archives, physical medicine and rehabilitation and biomechanical engineering online?
I am, yes. Well, usually if you publish articles in a journal, usually that journal comes back to you and asks you to be a reviewer. So I certainly do that type of work as well.
I'd like to ask you a couple of questions about your ongoing education, your professional education after your PhD. Have you continued your education in areas of biomechanics and high-impact injuries from the NTSB?
I have. I've taken classes through the NTSB and SAE, the IPTM, Police Technology Management Training Center. There's several different entities I've taken biomechanical and accident reconstruction courses through.
So the alphabet soup, if you will, of biomechanical
all the
engineering
letters.
and human factors.
Right, yes.
And you continue that today?
I do, yes, sir.
Any specific training in human kinematics?
Yes, I do have training in human kinematics.
Just out of curiosity, how would you define what is kinematics?
So kinematics is the motion of the human body and looking at how the body moves. And it's irrelevant or irrespective of the forces that cause that motion. So we're really looking at for instance, how one body part moves with respect to the next. We can see how the body moves as a result of a specific type of event.
You mentioned injury mechanics previously in one of your answers. What is injury mechanics and how does that relate to biomechanics?
So again, that's a subset of biomechanics looking at the response and the strength of the different parts of tissue of the human body. On a very basic level, to get an injury or have an injury occur, you need really two factors. You need enough force to cause injury to the tissue, and you need that force applied in the right manner. So if I wanted to fracture my elbow, I certainly couldn't take a hit on my shoulder and expect my elbow to fracture. Its force is exerted in the wrong location. And likewise, if I just lean my elbow on the counter here, that's not enough force. So you need the force and you need the application of that force in the correct manner to produce what we call an injury mechanism.
And have you ever participated in any studies or research in this area? In addition to your dissertation, getting your PhD, what about additional studies and research in this general area?
I have, yes, sir.
Can you describe that for us briefly?
Certainly. Well, just at ARCA, I've worked with the United States military. We worked on the design of the MRAP vehicles, the mine-resistant ambush-protected vehicles over in Iraq and Afghanistan.
That's a troop carrier, correct?
That's correct, yes. And the issue there is they go over the IED, the improvised explosive device, and it blows the vehicle up off the ground. So you're getting very large forces and accelerations through the vehicle, through the seat, into the soldier's spines. So we're seeing very traumatic and severe spinal and head injuries. So at ARCA, we work on what we call an energy-absorbing seat design. So when the vehicle gets blown off the ground, that seat is designed to absorb the force and the energy to protect the soldier's spine and their head.
Did you take part in the design of that seat?
I did, yes, sir.
Has that been employed by the Department of Defense?
Yes, it has been.
And are troops utilizing that new seat design, that safety seat design, in that troop carrier to this day?
As far as I know, is from what they'll tell us, yes, sir.
Understood.
What they'll tell us.
Are you also published in this field?
All I just know is they order a lot.
I am, yes.
Can you give us a couple of examples of current studies that you're involved in or publications that you've done in the recent past concerning bioengineering and the impact or the association that it has with human factors?
Sure. I mean, and another project I'm working on is we work with the NHL actually at ARCA. We have an ongoing
hockey.
Well, we have an ongoing relationship with the Department of Player Safety. For instance, we helped redesign part of the rink. In every arena, they had at the end of the player area, there was basically a 90-degree stanchion where the glass met. And so players were kind of getting checked down in the boards and then hitting up against the glass. And actually, somewhat ironically, it was Chara hitting Pacioretty into the glass, the Boston-Montreal game, and caused a cervical fracture and concussion. And the NHL came to us to see if we could have a redesign of the rink to make it a little safer. So we took crash test dummies, the anthropomorphic test device, which you've probably seen on TV, the automotive manufacturers use them all the time, and threw them into different configurations of glass. And now in every arena in the NHL, it is basically a curved piece of spring-loaded Lexan or plexiglass, where the players now, they hit into it, it absorbs the impact, and they glance off of the glass.
Is that a design that you helped come up with?
It is, yes.
So both from the United States military as well as professional sporting leagues, they've come to you to help save lives, lower risk.
That's right, mitigate and prevent injuries, yes, sir.
We can't right now because he's under the desk. We're not sure
what about
why.
Crash and sled testing?
Yeah, I've performed a number of crash and sled tests. When you look at any vehicle that's driven in the United States, it has to pass federal motor vehicle safety standards. There's federal regulations that they have to pass. And part of that involves running the vehicle into a wall at 35 miles an hour, hitting it from behind, rollover type impacts. And they have these crash test dummies in those vehicles. So we perform a lot of testing for different cases and situations where we put that dummy in the vehicle and we evaluate the safety system, whether it's the lap and shoulder belt or if it's the airbag or the seatbelt pretensioner, determine how to make the car safer. And part of that is looking at the force that's exerted on that dummy, because there's tolerance values. We know how much force it takes to cause specific injuries. So we want to make sure in certain instances, at certain speeds or impacts, that if someone's in an accident, the force acting on, say, their head or their neck or their chest is going to be below these established tolerance values.
Speaking of how much force it takes to cause an injury to a human body, have you engaged in any testing or published in the field of auto-pedestrian incidents?
Yes, I've been involved in a number of studies where we're looking at auto-pedestrian type impacts. Again, a lot of times we'll utilize the crash test dummy where we'll set it up and we'll actually have it struck by different vehicles or different objects to look at the response of the body. It's very important if you're talking about an auto-ped type impact, you have to know the configuration of the pedestrian, the vehicle, where they hit on the vehicle, whether it's a projection type impact, a wrap, a fender vault. It really all depends on how the person's positioned and the amount of force and speed involved in that type of an impact.
Both
And
projection
staying with
and
that
wrap
for a
sound
second,
painful.
That basic subject matter, have you also engaged in studies related to slips and falls where somebody might fall from a standing position and injure themselves either to their head, shoulders, whatever, and those kinds of injury impacts?
I have, yes. And I mean, one of the issues we look at it there is a lot of people fall, especially elderly people. So we want to look at what types of forces are being produced. You look at hip fractures, if you slip and fall backwards, head fractures. So we're trying to determine how to prevent those falls from happening and also create devices or products that can help actually prevent injuries if someone does take a fall.
Doctor, have you been retained as an expert in the area of biomechanical engineering and human factors in the past?
I have, yes, sir.
May I approach, Your Honor?
Yes.
Can you take a look at that
The
document
witnesses
and tell me
just
if you
get better and
recognize
better.
This is a list of my deposition and trial testimony.
it? Your Honor, I provided that to the court this morning.
Yes, I appreciate it. I had a chance to look at it.
Okay. That's about I don't want to go through everything. That's about a 14-page document. Is that correct?
That's correct, yes, sir.
Let me just ask it this way. How many times do you think you've been qualified as an expert in the field or testified as an expert in the field of biomechanics, biomechanical engineering, and human factors?
I've testified probably over 150 times in numerous state, federal, civil, and criminal courts throughout the country.
Your Honor, move to, I'm sorry, may I approach?
Yes.
For the purposes of voir dire, Your Honor, I would ask that this document be marked.
Sure.
Thank you.
I went back and looked at the slow motion replay. They panned back away from the witness.
Have you ever testified?
And Lally was just like tapping his fingers on the desk.
I have, yes.
I counted 3
How
taps, which
recently
means I'm out. I'm done. I give up.
Well, actually, I've testified twice. The end of May, I think May 31st, I testified in McKean County, Pennsylvania. For the prosecution, it was a case where the defendant was accused of beating his girlfriend to death and basically said that she fell down the steps. So my testimony involved determining how her injuries occurred and that they were entirely inconsistent with what would have happened during a stair fall.
What about another case?
And then about a week after that, around June 6th or 7th, I testified in Cambria County, Pennsylvania, again for the prosecution for another homicide case where the defendant was accused of essentially beating his wife to death and then said that she actually fell backwards and struck her head, caused a skull fracture on the side of the sink. So my testimony, again, pertained to looking at the injury mechanisms and determining that his story of her falling back and striking her head on the sink, it's inconsistent with the injuries and the type of force that would have been exerted in that case.
In both of those murder cases, you were hired or retained by the prosecution in the case, not by the defense, correct?
That's correct, yes, sir.
You gave your opinions in furtherance of the prosecution's case in chief, not the defense case in chief, correct?
That's correct, yes.
With regard to this case, you were asked to look at several items. We've already gone over those in the other testimony, so I won't belabor that. You were asked to look at several items, correct?
I was, yes.
And ultimately, based on that series of information, that universe of information that you were provided, see if you could come to an opinion and conclusion concerning the incident before the court now, correct?
That's right. See if I could determine what happened, how the injuries occurred, and the events leading up to and during that process.
Without going into your conclusions and opinions, were you able to come to conclusions and opinions to a reasonable degree of scientific certainty?
I was, yes, sir.
You were not hired by the defense, by me, or anybody on the defense side in this case, correct?
That's correct. I was not.
You were not consulted with or hired by the Commonwealth either?
That's correct. I was not.
It was a completely independent agency, is
There's
that
another
right?
one.
That is correct, yes, sir.
Before this morning, have you and I ever met?
No, sir.
And we've never talked about, you and I have never talked about the substance of your opinion and conclusion, correct?
We have not. That's correct.
You did reduce those opinions and conclusions in conjunction with your team to a report, is that right?
I did, yes, sir.
And your understanding is that report was made available both to the defense and the Commonwealth in this case, is that right?
Yes, sir. That's correct.
I have nothing further.
Okay, Mr. Lally?
Wow.
Thank you, Your Honor.
He's already read. This one's coming in. This one's coming in.
Good guess.
Just a few questions.
Good
sir.
guess.
Good
Who was
afternoon.
that?
Good afternoon, sir.
Now, with relation to your work in this instance, in this case, were there any limitations as far as confidentiality or anything that were put on you or any of your team?
What do you mean by confidentiality?
As far as who, what, where, and how you could discuss what you did?
Well, yeah, I mean, certainly we just discussed with who we were retained by in this case. I don't believe I discussed the case with anybody else except for my cohorts who were also involved in the case.
And so my question, sir, more is geared towards, at some point you were made aware that your report and your findings were made available to both the prosecution and the defense in this case, correct?
I was made aware of that, yes, sir.
And when you were made aware of that, was there any limitations on given to you as far as who you could discuss your report, your findings, or anything with?
Yeah, basically given the direction or the request that I don't actually discuss the substance of my opinions or my report with anybody aside from who we were originally retained to work for.
Now,
really?
May I approach, Your Honor?
Yes.
Sir, I am going to show you the first couple pages
can't share his
of your
opinion with anyone
report,
but the
specifically
FBI.
right down the bottom. There's a list of items 1 through 14. I ask you to review those before you finish.
Okay.
Now, is that the totality of information that you and your firm were provided with in reference to what you did in this case?
I believe it was, yes, sir.
So nothing beyond that list of 14 things did you have occasion to look at, review, or have any opportunity to see at any time?
Well, aside from we did do testing in this case, so we did do other
Aside
work.
from your independent testing, I'm asking as far as material provided by whoever employed you, that is a sum and total of what you received, correct?
I believe that would be correct, yes, sir.
And did you personally review each of those 14 items? Because, and I don't fault you or your company for this, but within the report, there's a lot of wheat. So what I'm asking is, did you personally review each of those 14 items that are listed in that report?
I did personally review every bit and every page of information that was provided in this case, yes, sir.
And to be clear, just to sort of close the loop on this, when it comes to those 14 items, were you allowed to ask for any additional items, or was it just you were limited to, this is what you have, go form an opinion?
There may have been discussion about if there's other information available, but I believe ultimately that we rendered our opinions obviously just on this specific information that was provided to us.
Now, as far as your opinion in your report, when was that issued?
February 12th of 2024.
So that date on the top of the report of February 12th, 2024, that's when you sent the report to the people that contracted you to do the analysis in the first place?
That's correct, yes, sir.
May I approach, John?
Yes.
Thank you.
Sure.
Now, am I correct? And what I'm trying to ascertain here, Doctor, is just sort of the different roles that you and the other members of your team performed in reference to this. Am I correct in that your primary role in this pertained to the sort of biomechanical engineering analysis of injuries sustained by Mr. O'Keefe?
That would be correct, yes, sir.
And not to put too fine a point on it, but Dr. Wolf would have been more responsible for issues related to the vehicle itself.
Generally speaking, yes, that would be correct.
Obviously, there's some interaction between damage to the vehicle and injuries to Mr. O'Keefe, but as far as your primary sort of any opinions contained within this report pertaining to injuries to Mr. O'Keefe, those would be your opinions, correct?
Yes, any opinions or information with respect to the injuries would be my purview and my opinions in this matter, yes, sir.
And concomitantly, so any opinions related to damage to the motor vehicle, those would be opinions of Dr. Wolf, is that right?
Well, to some extent. I mean, certainly I would have opinions as well based on the interaction or alleged interaction between the body and, for instance, the vehicle in this case, and what damage to both the body as well as the vehicle you would expect. So I think there's basically some overlap between those issues. I wouldn't say that it's a complete separation.
And so, and again, Doctor, what your opinions or ultimate conclusions are, whether they be yours or Dr. Wolf's or a combination of the two, it's all limited based on the information and the evidence that you received, correct?
It certainly is based on the information that we reviewed and listed in our report. Yes, sir.
Now, as far as sort of a mandate or from the agency that hired you, were you asked to answer a specific question, or were you asked to just go do an analysis based on what we sent you, or how was that put to you as far as what you were doing?
There was a specific request that we were asked to perform and to evaluate in this case.
And specifically what I'm asking, sir, is there's an analysis in there of whether or not the injuries to the back of Mr. O'Keefe's head could have been caused from contact with the vehicle, correct?
That is part of my analysis and opinions, yes, sir.
And were you specifically asked to address or answer that question by the agency that hired you?
That was one of the questions I was specifically asked, yes, sir.
I have nothing further.
Anything further, Mr. Jackson?
Your Honor, thank you.
All right, so, Doctor, I have a couple of questions for you, sir. So regarding the specific request, what were you tasked to do specifically?
So specifically overall, I was tasked from the biomechanical standpoint to determine or see if it's possible to determine how the injuries in this case occurred. And part of that was determine whether the injuries, the head injury and the arm injuries resulted from contact with the Lexus in this case.
Okay. And regarding all of your prior testimony, a good deal of it seems to be in depositions. Any of those in Massachusetts?
There's a couple, I believe. I've testified at trial in Massachusetts,
Okay.
Middlesex Superior Court.
Do you know where that might be? I do want to look at that.
I can find it for you, maybe a couple of months ago.
Was it in a criminal case or a civil case?
Oh, it was in civil case. I
Okay.
think, let's see here. Yeah, so let's see. There was one November 14th, 15th, 2023, Middlesex Superior Court. That was probably the most recent one.
Okay, what number is that on there if I want to go back and look at it?
That is number 310.
Thank you. Is there another Massachusetts case?
Oh, I'm sure there are because I know there's some from earlier in my career. Let me see. See if I can find them for you real quickly here.
Andy has a report. It's like I'm going through all this experience and testimony and times I've been certified as an expert witness. Let's see, just in your state, let me extract those.
Connecticut.
It's close, but not Massachusetts. It's different.
Louisiana.
There's so much experience on here.
Oh, there's 68.
Here's one.
I'm gonna butcher it. Worcester.
Is that a civil or criminal case, Doctor?
That is a civil case as well.
Okay. What year was that?
Oh, that one was 2012.
Okay. Any others that you think of or you see?
There may have been a couple others. I don't recall off the top.
All right, I'll go through it more closely. I
Sure.
appreciate you saving me some time.
Absolutely.
All right, any questions based on my questions?
No, thank you, Your Honor.
No. All right, you are all set, sir. Thank you very much.
Thank you, Your Honor.
So what's your consensus? He testified about Worcestershire sauce. Judge
All
has to
right,
rule about
so,
these three.
Mr. Lally, I will hear you on your motion. Now, we didn't get into the ultimate opinions and the basis for that opinion.
Because it's just
but
Dahlberg.
I'll hear you on your motion.
Your Honor, what essentially what Commonwealth was seeking and had been seeking was just in reference to that, as far as who did what and who was responsible for what and what were the items reviewed, and is that the totality of it? There's a date on the report. I don't know if that was a date as far as when it was filed, when it was opinion was rendered, when that was provided, what was provided to them in the course of their analysis. So I think very simply what the Commonwealth had been seeking for the most part was covered today.
Okay. All right, I have some questions as to the scope of the testimony of the witnesses.
Scope.
So, Mr. Jackson, you intend to have them testify consistently with the report, everything covered in the report?
Correct.
And the conclusions, all 4 conclusions in the report?
Correct.
All right, Mr. Lally, what's your take on this?
Why are we limiting scope on these two? I mean, we're not talking about how much Karen had to drink.
I do
that
have an
night.
issue with number 4. I don't think they're qualified to testify to. I don't think either of them is qualified to testify to that. That's more of an area of forensic pathology.
What do you say to that, Mr. Jackson?
Number 4 is, their opinion is, there is currently insufficient evidence to determine the cause of Mr. O'Keefe's skull and brain injuries or the circumstances surrounding the event. That is well within the scope of their expertise. Obviously, I don't think I have to beat this dead horse. They are highly, highly qualified to render all 4 opinions. And if the evidence in their opinion, their expert opinion, to a reasonable degree of scientific certainty, which is what's evidenced here by the report, is that there is insufficient evidence to determine the cause of Mr. O'Keefe's injuries, then that is an opinion that they are well within it's well within the scope of what they can testify to. That's their opinion, that's their conclusion. Mr. Lally is going to have an expert, Trooper Paul, who is going to differ, or who has differed in that opinion. So be it.
And I would have kept it out. Remember, I would have kept out any medical part had there been an objection. And when you objected, I sustained the objection.
No, I think we're talking about 2 different things, apples and oranges. That's not, Trooper Paul's opinion is that his injury, or his injuries, or I think he said variously that it was blunt force that could have come from the curb, or it was blunt force because the road is blunt. That was his opinion, and he was sticking to it. This is contrary to that. Both of these individuals have come to the conclusion and opinion that the evidence is insufficient to support that determination, and it's well within their purview to testify to that.
Your Honor, if I may, I don't think that's their actual opinion. I initially didn't think of it in these terms as it's phrased on the cover page of the report. If you look at the actual opinion
I
and
was looking at
findings,
the last page. Are they the same on the front and the back?
I think the front is a little more definitive and concerning. The back, I think, more as to it's consistent with a whole multitude of different things. So the fact that I don't really think that's an opinion at all, to be honest with you.
All right, I'll take a look at this more closely, give you a decision Thursday. All right, I did not expect it to go this quickly. We could have had the jury here, but I'm sure you all could use the afternoon to prepare. All right, Mr. Lally, let me know Thursday if you need, are you ready to go forward at least with your case on Thursday?
Oh, yes, sure.
Let me know Thursday if you need additional time. If I let these witnesses, if I let Dr. Russell testify, how that impacts our schedule.
Absolutely, Your Honor.
All right, but I don't want that to be a concern of yours, how it impacts the schedule. That's my concern. I just need to know. All right, so anything else?
For the Commonwealth.
I think that's it. Thank you.
Okay, we'll see you Thursday morning.
Court, all rise.
There's no jury. We're done. Wow. Okay. So if I understand correctly, this last witness, Dr. Andrew Rentschler, who just testified, and Daniel Wolf, was it Dr. Wolf, who testified before him, were hired by the FBI or Department of Justice to do this. They looked at everything that they were given, and they came to these conclusions. They had no dog in the fight. That's a bad example, but they didn't have any. They didn't have a hand in the game. Okay, how do you say this? They had no. They had no ulterior motive. There wasn't something they were pursuing, a certain answer they were seeking. They were just looking at the facts and reaching conclusions. And it didn't matter what they were. That whatever the evidence led, that's where they'd go. So they have all the pieces of evidence. They have the taillight, the measurements of the injuries and everything, and they put the pieces together and said they don't match. This is a problem. This is a problem for me personally. I've told you all along that I think that her car was involved at the scene there. If the pieces don't match, if the puzzle pieces don't come together, I now have to rectify in my head how we have Karen Reed's car on ring camera leaving her house before John O'Keefe's body is discovered with a broken taillight, missing pieces. And those pieces of the taillight being found at the Alberts' home. But according to these two witnesses, we expect them to testify it wasn't caused by John O'Keefe. Was there another accident? Is that what we have to say? Was there something else that was hit? Did she back into the plow of Brian Higgins? How do we get the pieces of her taillight at the scene of the crime if these two witnesses are correct? I don't know how to rectify that. I tell you, that puts me very, very firmly still in the not guilty category because I have not beyond reasonable doubt. How do those two pieces of evidence come together? Okay, if she hit something else, wherever those pieces fell out, they were collected from wherever that happened and placed at the scene. This goes into conspiracy, which I struggle with. I really struggle with the big conspiracy to frame Karen Reed. I think it was more, if there was anything, there were certain people who tried to pad, I think, in my opinion, I think that Proctor tried to pad the evidence. They were collected. That we know that the pieces were found. They were put together. They matched up. They were able to rebuild almost the entire taillight from those pieces. But whenever that happened, it was prior to 5 o'clock in the morning when she left her house on that ring camera. Prior to that, pieces were gone from her taillight. They were not in the taillight. There was nothing. It was broken open. Large chunks of particularly red plastic were missing. Those pieces were found at the scene, whether they were placed there or whatever. But if they were placed there, how were they collected? How does this all match up? I guess it could be one of the things we never know, but it does add to the not guilty category if the injuries on his arm are inconsistent with the scratches and the marks and the cuts he would receive if he got hit and broke the taillight. And we have all the math now. We have all the math that's going to be coming in. There were big pieces found much later than the small ones. I think the first pieces were very small. What if the taillight cracked on impact, but pieces didn't fall out where the impact happened? I'm okay with that. It can be whatever causes the break, but at that morning when she drives out as it's snowing, she backs out, hits John's car. I've done zoom close-up pixel analysis. There appears to be no pieces of taillight that fell to the ground at where John's car was impacted. It doesn't look like anything was, I can detect little tiny changes in the snow. Yes, there's a tiny mark where it appears that some snow was brushed off on the back bumper. I've zoomed into like pixel size till they're this big and compared the pixels. I can see that. But there's no taillight pieces that come out, which means they had to have been broken out previously. Because we know as she drives away, we can see the missing chunk. There's nothing there. There's no taillight plastic in that area. Those pieces were found at the accident scene. To me, that says that up till this point, that proves that the car was involved in an accident there at the Alberts. But if the people who put the pieces together also match them up to John O'Keefe's arm and they don't match, then that's a not guilty. I hope these witnesses come in. I hope they come in. We're going to find out tomorrow morning when we continue with this case. The decision's been made today. I'm not peeking. Wow. Oh man! All right. What do we do from here? We have. Let's see if we have. Let's see. I'm not sure when Corey Richens is going to be up. Do we know? Let's jump in with Judge Fleischer just for a minute. Can we do that while I do a little peeking around? Quick court hopping.
Johnny.
Yes, Judge. Good morning.
Hey, bud. Did you take care of that issue or no?
Yes, I did. Actually, Judge, that's why I'm approaching. He did bond out. He posted 2 bonds for the criminal and immigration bond.
For real?
Well, it was one bond out of his criminal case, and then it was a $10,000 immigration bond. But we went ahead and figured it out. He's out.
Paul Wright, welcome to the jury.
The reason for me approaching today, his case number is 2510521. And the name is Eduardo Rojas. And I filed a bond modification overnight. What we're trying to see is if you would modify his travel restrictions and his curfew. It's all job related.
Where is he?
He is currently here in Houston. I mean, he's out.
I need him so we can do PC and bond conditions.
Okay. Would we be able to possibly come in tomorrow, Judge?
Yeah. I mean, I don't know anything because he's been in custody the whole time. So we haven't seen him. We need to do, PC. I need to do conditions. I need to do the whole shebang. If you can bring him tomorrow, we'll get all that, and then we can talk about bond conditions.
Okay. Thank you, Judge. I appreciate it.
For sure.
All right. Thank you.
Okay.
I can see Corey Richens has a
Nick,
2-day hearing, but I can't see anybody carrying it live.
Logan, did you have any luck with Nick, they haven't had any luck getting a hold of the person. So you want to try tomorrow, perhaps?
I can, Judge, yes.
If I'll give you time, that way. I don't want to do anything until I know that the complaining witness is fine, feels protected and safe. And then I'll do it, Nick.
Okay, I'll circle back tomorrow, Judge.
Yeah, okay. Just take your time. Hopefully you can get it by tomorrow. If not, then I guess the next day until you can.
Are you driving, sir? I like this is Vicky's favorite judge. It's just noisy courtroom. Noisy courtroom is all we're getting. Okay. If there was more action, we'd look at it. But wow, what a day! I'm just amazed. The judge has the judge in Karen Reed's case has a huge decision to make. And I'm hoping that it comes down in favor of hearing those 2 witnesses, because I think they are completely impartial, especially the last 2. The dog bite witness, I can see she sought out the defense. She wants to testify. She's supremely qualified, even though was qualified before I was born. But oh man. See, I'm trying to see what else we have going on. Louisiana Parole Board is up. Oh, haven't seen Judge Boyd in a long time. Does she have a case right now, or is she just doing regular court? Does anybody know? Take a quick peek.
Ms. Ferguson, have this brought back for June 24th for trial. There we go. He'll be dressed.
Thank you, Judge.
Is there anything else?
Nothing further, Your Honor. May we be excused?
Yes.
Thank you, Judge.
Well, just one moment.
Oh.
I need an acknowledgement of discovery file.
We did that, but I'll do it again if not.
All right. And Ms. Ferguson, have him brought over dressed for trial on Monday. Denzel Apia. Help me with that pronunciation.
You did good, Judge.
All right, thank you.
Morning, Your Honor.
Hello, counsel, you're on this side. All right, so this was reset so you could go over discovery.
Judge, yes, we got an offer today from the state, so we just asked for a reset, Judge.
All right, how old are you?
19.
All right, Ms. Ferguson, recall this for 30 days for a plea deadline date. And it's Denzel, how you pronounce your last name?
Apia.
Apia, all right.
Judge, I have a vacation letter until the week of the 22nd, so is it possible to get that week?
All right, Ms. Ferguson?
It's about 30 days.
What is your vacation letter the week of the 22nd?
Judge, it's from the, I think the 4th to the 19th, so the 19th.
All right, if you
Friday.
put it the week of the 22nd, Ms. Ferguson? All right, July
Your Honor.
23rd is your plea deadline date. Make sure an acknowledgement of discovery is signed. And once you've done that, you're excused.
Thank you, Judge.
You're welcome.
Yeah, excuse me.
Yes.
Thank you.
Who's here on Amberly Perez?
She's got a lot of pretty flowers there on her desk today. What's the ones in back? Those tall, skinny, finger-like ones. Are they irises? Just haven't bloomed yet?
Court is calling 2022 CR 6214, State of Texas versus Amberly Perez. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Eric DeWalt, I represent Ms. Amberly Perez.
And are you Ms. Perez? Yes, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
All right, off the record for a moment. You all are going to have to move down there if you want to talk. No talking behind the court reporter while the court is on the record. And you'll need to ask the deputies to move your client. We're back on the record. Are you the same Amberly Perez who was placed on deferred adjudication in 2022 CR 6214 for the offense of aggravated assault with a deadly weapon on September 13, 2022 for a period of 7 years?
Yes, ma'am.
All right, state.
Violated condition number 38 in Bexar County, Texas. The defendant, Amberly Perez, then and there failed to submit to drug testing as directed by the court officer, supervision officer for the month of June, August, and October 2023 in violation of condition number 38.
How do you plead to that? True or not true?
Your Honor, state waives all the violations.
Any objections?
None, Your Honor.
Did you understand by pleading true to violation of condition number 38, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition 38?
Yes, ma'am.
Court will find violation of condition number 38 true. Is there a proposed agreement?
Your Honor, it's to the defendant to go to the scene.
Your Honor, that is the proposed agreement. We are also in agreement. I know Ms. Amberly is ready to make a change in her life, and we'd ask that she please be given this chance.
All right, Ms. Amberly, here's the thing. You know yourself better than I do, better than your counsel does, the state does, and probation does. You need to ask yourself if you're going to be serious about this probation and if you want to successfully complete it. Sometimes people will say they want to successfully complete probation and they do not do it. What ends up happening is they continue to use, they don't report. So I'm going to give you a choice. I can sentence you to 5 years in the prison today, or you can go to safety. All right, state your excuse. And probation, is this your recommendation?
Yes, Your Honor. She was previously ordered safe P but failed to self-surrender, and probation feels that she could benefit from the substance abuse program due to her drug program. Problem.
All right. So I regret that I didn't know that you didn't surrender to safe P, because if I would have known that, something else would have been done. And that's my fault for not speaking to probation before then. If you fail to follow the court's orders and come back before me, if the state is able to prove up any allegations, you're looking at, if I don't continue, you're looking at up to 20 years in the prison. You understand?
Yes, ma'am.
All right, I'll deny the motion, alternate amend conditions to include safety, and she's to remain in custody until transfer.
Wow.
And I'm going to extend her for 1 year. Is there anything else?
Nothing from defense, Your Honor.
Is there anything else you need from the court to be successful?
We're watching
right,
for
then
the
let's
hearing.
see.
Honor,
We're watching for the
excused?
hearing
Yes.
Thank you.
You're welcome.
for Corey Richens. Have not seen anything yet. We're also looking for Sarah Boone's letter, which is long overdue.
Number, what page is she on?
Page 10.
Thank you. All right, who is here for George Hawkins? All right. And probation, this is an application. Court is calling 2024 CR 5390, State of Texas versus George Hawkins. Can I have parties announced for the record for the state?
Andrew Vera-Sadelman.
Defense?
Renee Munoz on behalf of Mr. Hawkins.
And are you Mr. Hawkins?
Yes, ma'am.
Counsel, have you received all the discovery?
Yes, Your Honor.
And did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Hawkins, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it?
Yes, Your Honor.
Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Hawkins, did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of assault of a peace officer or judge bodily injury as a second-degree felony? Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine.
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
that's correct, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Hawkins, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 6 years in the prison. The state is silent on your applications. They're taking in consideration 2023 CR 7315, 2024 CR 53389, and County Court Cause number 729000. Did you understand that to be the plea?
Yes, Your Honor.
Defense is at the plea.
Yes, Your Honor.
State is at the plea.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motion?
No, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
I believe contained in Exhibit 1 attachments, Your Honor.
All right, state, you may be excused.
Thank you, Your Honor.
Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states Exhibits 1 and attachments, and the court will review the same.
She's reading all the notes. This guy attacked either a peace officer or a judge. That's not good. I think we need bailiffs a little closer. We're about ready to go to lunch, so we're going to wrap it up. I don't know if we're going to have something that happens this afternoon. I'm going to keep my ear to the ground and see. There might be a small trial. I'm going to have to see if we can speed record, because it will be gone after when they hang up. They stop and the whole thing disappears. So we'll see. We'll see what happens. But thanks, Josh, for that one. I'll take a look at that one. She's reading all the notes.
All right, after reviewing states Exhibits 1 and attachments, the court will find there sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. We'll be back on August 1st for sentencing. I will base my decision on a PSI report, the TAP evaluation, and any other evidence that's presented. Do you understand?
Yes, Your Honor.
All right, is there anything else needed other than a PSI and TAP evaluation?
Nothing further, Your Honor.
All right, thank you.
Thank you, Your Honor. Ms. First, thank you.
Have a seat, sir.
I'm going to jump over to a different court really quickly.
And so you are
Is this our drug
asking
court?
the court, or you're stating to the court that you do not wish to have the ability to change your last name to your maiden name. Okay.
You do not wish to have the ability to change your last name to your maiden name. It's a divorce. We've seen her
Anything
and this
else
judge
that
in
you wish
drug court.
to let me know or to ask for?
No.
Are there any debts of the marriage?
No.
No debts. All right. Mr. Sears, did you have something else to say?
Yes, as for the cats, last time I was there, Big Red was sleeping on my side of the bed. He has like you said, he has his own pillow. He would lay his head on the pillow right where I was sleeping. As for the farm, I'm done out there. I'm waiting on a phone call right now from my back surgeon about putting a spinal stimulation at putting a spinal stimulation in. He gave me the choice of stimulation or more back surgery. When I got a hold of the farm out there, that's it. I'm done. If I can't get in a tractor no more, I'm done out there.
All right.
Is he asking for the cats?
So is there any way that, well, let me know about these boats. The one John boat, you've had that prior to marriage?
Yes,
But when did you buy this fishing boat?
3 years ago.
That's communal property.
Okay. Okay, and is there value to this Tahoe and this Expedition and this 14-foot fishing boat? Are they worth anything?
I would say yes.
And if so, what is your best guess?
The boat would be maybe $50. The Expedition, that's junk, that's scrap.
What about the Tahoe?
There's still lien on that.
How much is owed on that?
I'd have to get a hold of them. I think it's in my financials here. I think this, something like 45.
I don't like
$100?
watching
Yeah.
a divorce,
Yes.
but this judge is absolutely phenomenal.
4,500, do you think?
Well,
Oh, yeah, you say 4,427 is what you say is owed.
Yeah.
All right, Ms. Sears, as to the value of the Tahoe, do you think that how much do you think it's worth? Is it worth more than that loan amount that's still out there, or do you think it's worth less?
I wouldn't have the slightest. I'll be honest with you, I don't care. I mean, I understand it's his. He got that after we separated, so I have no.
All right, so it was after you separated. What about this Expedition?
Well, it was still worth like $2,500 a year ago.
The boat's
I
only
beg the difference on that because it was not running. Had barely run a year ago.
And he says it's worth $0. I don't have anything to tell me otherwise. And you have no problem giving giving him the ability to have ownership of that 14-foot fishing boat?
No.
Or that John boat?
No.
Okay. All right, I'm gonna ask each of you for some arguments. Mr. Sears, this is your last time to tell me anything, to argue anything to the court.
The Copa John boat, that's personal property. I owned that before we even got together. I have not seen her taxes yet. I do not know if she has filed homestead taxes and claimed me on there.
Okay, this is the first time you're bringing up taxes, but she can't legally claim you if you haven't lived in there.
I know, but I still don't know. I'd like to see that.
First time you're bringing it up, and we've
Yes.
closed evidence. You're now in argument.
Okay.
That's a little late.
There's been lie after lie after lie coming out of her. She has said a lot of mean, nasty things to me.
Okay, this is just
especially when it comes to the loving, the intimacy and the sex.
Yeah, we're gonna
She
bail on this
has
one.
Really, what she has said to me about that is not right. It's completely wrong.
And there we go. Now we go from there to Judy Reese, I think she means assistant. I'm not sure if this was jumping into the fire out of the frying pan or let's go to lunch. Let's go to lunch. Oh my goodness. Sorry, Judy. I'm sure you're I think a judicial assistant would be my guess. The abbreviation, we're gonna see if we can speed watch that trial. It's one Josh sent me. Everyone's like, what court was that? The one we were just in. Not this one. This one here.
And a lot of things that are going to eat you up and probably cause more physical pain than the actual physical
Burnett
pain
Circuit
you're going
Court,
through.
Branch 1.
Because stress, anger,
Live.
all of that, it does a whole lot of bad things to a person's body.
You guys can watch it on lunch and
I
fill
forgot
me in
to
on
ask,
the
how much
details
do
if
you,
needed.
how, do you work full-time?
No, I work 2 4-hour days a week.
Why?
I've had 2 back surgeries and it's all I can handle.
I like the
All
judge.
right.
Why?
Well, I've seen a lot of anger in divorces, obviously, but I've seen divorces that have been quite pleasant.
I like this
Surprisingly.
judge. Oh my goodness. I can't
This
leave.
one is not pleasant. This one, I see venom and fire out of both of your mouths and both of your ears. And if looks could kill, I think I've seen about 20 deaths today. Because I don't think either of you respect each other in the slightest. And that's sad because at one time you loved each other more than the world. You loved each other more than your own lives themselves, and you got married and you wanted to spend the rest of your lives together. And during the course of 2011, I believe, when you said you got married until present, something happened that had total destruction and devastation and caused a whole lot of spite. The court finds, based upon the testimony of the parties together, and I will receive your financial disclosure statements and I will receive Exhibit 1. All residential and jurisdictional requirements have been met. The applicable waiting period has lapsed. I do find that the marriage between Lawrence and Melissa Sears is irretrievably broken. There is no chance of reconciliation. I will find that the waiver of maintenance done by both parties has been done freely, intelligently, and voluntarily. And in spite of the waiver of the maintenance, we are talking a 13-year marriage, which may or may not be a lengthy marriage for the court to consider maintenance, but based upon the income of Mr. Sears and the fact that he only has Social Security disability with some additional income on the side, and the income of Ms. Sears working 2 days a week at 4 hours a shift. She could work more. I don't have medical documentation that can show that you can't work more, and you have the added benefit of no rent, no utilities, no etc. So based upon these factors and these things, the court would not order or award maintenance to either party anyway. I will find that Ms. Sears will not have the right to resume her maiden name. What is your maiden name, just for the record?
Asbury, Asbury.
She may not return to her name of Asbury. If she does so, it must be through a separate legal action. I'm going to award all personal property located in the garage to Mr. Sears. And that would include your ice fishing, your summer fishing, your 3-man Eskimo fishing house, your waffle maker, your mini donut maker, your 12-foot John boat, 3 snow blowers, and hand tools. I will also award the 2 vehicles to Mr. Sears, the Tahoe and the Expedition, subject to any lien that you have on them. I will state that Ms. Sears must reasonably look to find all of the important papers that Mr. Sears is looking for. He can order his own birth certificate, but if you find one, that's probably better because it sounds like he's having a difficult time. I don't know why or how, but you have to do reasonable due diligence to try and search and find those documents. And if you can't find them, I can't order any penalty because I don't know. And you state that he took the drawer that had these. He says he did not, but maybe they weren't in the drawer. Maybe they were put in a different drawer. So you just must search for them and use all reasonable diligence to locate them if you can. I'm going to state, well, first I'll ask Mr. Sears, how long do you need to retrieve that property? Because you will get one shot, one day.
Next Friday, like I said, with the emergency visit with the vet, with my dog this morning, she has something neurological going on with her, and it's going to take she could clear up in 3 days. It could take a week.
So do you need more time? Because if I say Friday, you can go get the stuff. That means it's Friday. That you go get
Next Friday, yes. I just need a week to get her straightened out. That's my more worry. She's 15 years old right now.
And I believe there's an injunction between the parties, and he does not need to go into the home, correct?
No.
So can you have the garage unlocked but shut?
He has it rigged, so only he can get in there anyway, except through the door. So it's no issue.
Just make sure it's unlocked so he can go, and if it is rigged, unrig it so they can use the garage, okay? Because you don't want some other civil matter, small claims matter with Papa Vinny coming after you to try and say you damaged the property. So
the door's not locked. There is no lock on
okay,
either
well,
door.
just go get your property, and you have Friday from 8 a.m. until 6 p.m. to remove your property. You may have zero contact with Miss Sears. Probably he shouldn't have contact with Vinny either. Okay, so just go get your property, remove your property. I don't know where you're going to store it, but that's for you to determine. As to the cats, this is a more difficult one because I get that my pets too. I may sound callous, I may sound cold, but that's because I'm in my judge hat. I love my animals. They are like my children as well. And when you lose one, it is a death, as if it was a family member. I get that. But in the courts and the law's eyes, they are assets, they are property. There are 4 cats involved, and 2 of which Mr. Sears has not asked to receive. One of which, of the 4 cats, he has a better relationship with. I'm going to say for the most part, I see why you would like the animals and to have all of the animals, Miss Sears, but I don't have a doctor's note saying that they are emotional support animals. I don't have anything to say that if you have 3 versus 4 or 2 versus 4, that's going to provide you any more or any less protection from your anxiety or comfort from your anxiety. So with regards to the cats, I'm going to order Big Red can go to Mr. Sears. You can keep Junior and the other 2.
I can't keep Junior. Junior will die without Red, so Junior will have to go with him.
So then you get Junior and Big Red.
Thank you.
As long as you're going to take care of them. She doesn't have to give you a litter box. Buy your own litter box. You can go to a thrift store and get a used litter box if you don't think you have money to buy a new one, but they're not that expensive. But you're putting the burden now on your mom to have your animals. So you got to figure something out. You need to have a more stable residence because they don't deserve to not be with you, and they don't deserve to have your mom take care of them. They're your pets.
I'm there every day.
Well, good. I'm glad, because apparently if you're staying in your car, then you need somewhere to hang out. So I understand, Ms. Sears, and I know that it is a devastating order to have cats go to Mr. Sears, but
I had accepted it.
Okay, so I think that covers everything. Neither one of you are able to remarry anyone in any jurisdiction because it would be a void marriage. It would not be a legal marriage. I do need to order that both of you or one of you can go out and fill out the findings of fact document that you need to fill out, and then give it to the clerk, and the clerk will make sure that the other person reviews it to make sure it's accurate. Then it will be filed, and I will review it to ensure the accuracy of what happened today, and I will sign it. As of 11/18, you are now officially divorced. Okay, you are divorced. So hopefully you'll be able to avoid each other and not have contact, but for the exchange of property. Mr. Sears, do you have a carrying case where you can get your cats and have them, and you can have somebody either drop it off ahead of time, or you can go your first trip to get your property, leave the carrying case, and make sure then Ms. Sears can put the cats in that so that they can be brought back to your mother's home?
I can get 2, yes, but it's gonna be kind of tough to get Big Red into a carrying case, so.
I don't think if you can't get them into a carrying case, it's gonna be difficult to get them into a vehicle.
Oh, I can get them into a vehicle. It's the carrying case is what the issue is.
But I don't know how I can facilitate that without having contact with you and Ms. Sears, and that's
How are
not
they gonna,
okay.
he's just supposed to just set them out on the step in the carrying case and wait for me to come get them?
Put them in the garage, yes. You drop off the carrying cases when you go to retrieve your first load of property. You leave them there. She goes and she gets them. She puts the cats in. She puts them back in the garage. And then when you're there for another trip, you take the cats.
That's fine.
I do have another option. If Carolyn would be willing, she could come over today and I could give her the cats and she can take them to Larry.
Miss Carolyn, is that something you'd be willing to do? He says, sure.
So we can do that today.
Okay. So if she can facilitate that, she can come and get the cats. Make sure you have food. I'm not gonna order her to provide you with any food or anything like that. But I'm gonna guess that she loves the cats and wants to make sure they eat, so she'll at least provide you a day's worth of food. But they need food, they need a litter box, they need to be able to have things, and perhaps Red's blanket and pillow.
And his toys.
And his toys. All right, anything further? Mr. Sears?
Other than taxes, that's it.
Well,
Too
I've heard nothing about the taxes. The taxes that was shut off. And
Okay, that's fine.
so you're divorced, and so you file your own taxes, she files her own taxes, and then you move on from here. Okay? All right.
On that note, we're going to go to lunch. I'm sorry. That is heartbreaking and sad. And at the same time, it seems, yeah. I love that judge. She has a heart. She understands things on a personal level. And can relate to people on a personal level, and I like seeing that. It's very sad to see two people that cannot get along well enough to even decide what's best for their cats that they share. That's all. So we're gonna go to lunch on that note. She's a good judge. She has some good stuff. Her I want to see her in a criminal setting, but her work with drug court. Oh my goodness, it's amazing. Absolutely amazing. CC, thank you, RA and Mods. 14 months. CC, wouldn't be the same without you. Thank you so much for being here. Let's see if we have any. I don't want to miss any as well. We're about to go to lunch, so let's see. Kay in South Carolina, we had 17 months there. Amy Manzi, 15 months. Nikki Zeebs, I saw that one. Teresa Super, member for 2 months, 2 great months. Braxton Heaps, good morning. What did I miss? Not much, apparently. DSN, gifted a membership. Rybear, something for the mods. They deserve it. Melpoy, thank you very much for the super chat. Paul Wright, welcome to the jury. And CC, thank you, RA and mods. I appreciate all of you. Thank you. We are going to go to lunch tonight. When you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe till we go live again, possibly after lunch. Here's what we're listening for. We're looking for this case right here. With Judy Reese, the judicial assistant, I think. We're going to look at that. We might record that, see where that's going. If we can, it might be pulled down and we might miss it. Either way, it's going to be a short trial. I think it has to do with the stabbing at a Dollar General or something. That might be interesting. I'm watching for Corey Richin updates out of Utah, Park City, and we're also looking for Sarah Boone's letter. So that's what we have in mind this afternoon. I can't promise we have any of them, but if we have anything, we will be back this afternoon. Hope you can join us tonight as well. We've got the podcast, 8 p.m. Weather Watch myself. We're going to have a lot of fun. Please join us. And that's all. We'll see you. Be good to each other, guys. See you in a bit. Bye.